Yes, tell me.
Made to your lordship. My lord, with the consent of the other side, my lord, I beg to mention item number 50 and 52, my lord. In both the matters, I have filed my affidavit, my lord. But due to some medical emergency, lordship, I have to leave the court early. Lordship may kindly pass over the matter. Adjourn the matter for
50 and 52.
my lord. In both the matter, I have filed my affidavit.
I am appearing in item. I am the petition.
If you want to go use. ওই বেটা ঠিক করে নেই এটা করে yes
In item number 50, I am for the petitioner here.
I was about to dismiss on first day itself. Yes.
Lordship is not audible.
You're not audible. I'm not audible.
Yes, lordship. Audible.
I've asked them to remove these glasses. I think by next week you may not see these glasses. Okay, we'll have it on when?
First week of June. Any day.
It's 50 and 52. 7.
Lordship, 7th, my lord.
7.
I'm deeply obliged, my lord. In the meantime, they may file their reply. Deeply obliged.
I beg to mention item number 25, my lord. This
25.
matter, 25, my lord.
Yes.
In this matter, my lord, today we are filing an additional affidavit for reducing some documents, my lord. So kindly take up the matter next week, my lord. Other side is permanent.
Request to the
Lordship,
learned
I am-
counsel for the petitioner, matter stands adjourned for 4 weeks.
Lordship,
My
obliged.
lord, 2 weeks, my lord.
No, you should have filed. When did you get that affidavit? When did you file?
If it has not been.
When did you file the affidavit?
Lordship, no, Lordship, he is filing an additional affidavit, Lordship. I will file my affidavit after 2 weeks, Lordship.
You have not filed.
Not filed.
Heard, Mr. Your name?
K. Uddin, my lord.
Uddin, the learned counsel for the petitioner, and Mr. N. Upadhyay appearing on behalf of the Irrigation Department. It appears on record that the Irrigation Department have not filed the affidavit till date. So the petitioner also wishes to file an additional affidavit, taking into account the same. Let the matter be listed again. Okay. To be again listed on 14th of June.
Obliged, Lordship, obliged.
Mr. Pleasure, Lordship. Lordship, I beg to mention item number 24, Lordship. I have taken consent to the other side, Lordship. In this case, the higher education department has to file affidavit, Lordship. We need, Lordship, 3 weeks time, Lordship.
Regarding?
For filing of affidavit, Lordship.
This matter pertains to what?
Regarding, Lordship, the UGC scale of pay, Lordship. Petitioner is getting the state scale of pay, Lordship. He is claiming UGC scale of pay.
The request of Mr. K. Gugoi, the learned counsel appearing on behalf of the Higher Education Department. But the 4-week time is granted for filing the affidavit. This is the matter again on 26th of June.
Obliged, Lordship.
Please, my lord. May I pray for the urgent listing of a matter for hearing, my lord. The matter pertains to the year 2020 and is filed by an employees union seeking a payment of their arrears salaries. These are the employees of the Escort Bank, my lord. And the matter was last listed on the 12th of this month. However, the matter could not reach, my lord. May I pray a short date may be granted, my lord.
Are this hearing?
My lord, for hearing.
How did the matter come up before this court as hearing in a matter of 2020?
My lord is handling these matters.
I know that
pertaining
I am
to the-
handling, but 2020 for hearing, it should have come up for, normally it comes up for admission. Is it there for admission or hearing?
My lord, for hearing, my.
We'll have it in July.
My lord may have
You-
it in May, any date, my lord.
May?
My lord. My lord, the matter has been prolonging for quite some time, my lord.
2020.
Matter has, my lord, the salaries are stuck, my lord. The employees are in great difficulty.
It was left
Yes,
over.
my- yes.
Try your luck with the registry and get it listed on a Tuesday and Thursday. Or get it for orders, then I'll post it somewhere. But for hearing, no, sorry, no mentioning for hearing.
My lord, in that case, my lord, June, my lord, if your lordship.
You do one thing, put it for orders. We'll fix a date thereafter.
Well, my lord, I'm obliged.
Wait, please, your lordship. Item number 43, my lord. I have taken consent from the other side, my lord.
Yes,
My lord, this matter, my lord, kindly adjourn for 2 weeks, my lord.
you file your affidavit.
No, my lord, I have to file, my lord.
Are you filing affidavit or getting instructions?
My lord, no, instruction I have received, my lord.
Then why? Why do you want
My
to file
lord,
an
I need
affidavit?
1 week time, 1 week time, my lord.
Did this court ask for you for filing affidavit or instructions?
My lord, on last occasion, my lord, I have taken time to file affidavit, my lord.
Then?
And I have received instruction, but due to failure on my part, my lord, I could not file my affidavit.
Are you denying the claim of the petitioner?
My lord, I have to take, my lord, further instruction, my lord.
The instruction? No, this court asks you for instructions or affidavit? There's a difference between affidavit there. The request of Miss
Arrears Dewey, my lord.
Arrears Dewey, the learned counsel appearing on behalf of the Soil Conservation Department. On to 6th of June, affidavit be filed by 20/6/2023 without fail.
Obliged. May I please, item number 28 of daily list, kindly take this matter at 2 p.m. lords.
There. 28. Why?
Such a matter is related to area salary, earlier occasion for 5 leftover matter, lord.
Can't help it, leftover with going to keep on happening. 2 p.m. What is the urgency? Let us see. It may reach. Don't mention it now.
Lords.
It may reach in the first half itself.
May I please worship I beg to matter number 28.
Huh?
Matter 28 mentioned.
Item number 28 you want to mention. Item number 21, she was there. We'll take it up. Yes, Mr. Bordloi.
Item number 54, can it be taken at
Why?
the last
Not there in the
occasion? We
list.
did not reach
54, it is already there. 54,
54, Lord.
it's there.
On last 2 occasions.
Can't help you, but it is there in the upgraded list. It will be taken up. I can't, but then also I have to maintain parity of the from 2. First item will be taken as 6. So it will go on like that.
My lord, I beg to mention item number 37, my lord, at 2, my lord.
37 is not there.
Not there, my lord.
Why?
My lord, there is an urgency, my lord. The urgency is a matter pertains to my lord, advance increment, my lord. Regarding one advance increment has been given to the petitioner, my lord.
For what?
There is a notification passed by the government, my lord. On the death notification, my lord, also, my lord, the other similar situated person has been given one advance increment, my lord.
That one, 3/7/2012, the Director of Secondary Education.
Yes, my lord. Subsequently, it was again, my lord, in 2016 also some other my lord, similar notification has been issued. Because
That is passing the B.Ed.
Yes, my lord.
B.Ed.
Yes, my lord.
I passed similar orders. Is it the same case?
Uh,
Where is the other secondary education? Mr. Khatunia, you are there. It's the secondary education matter, no?
Yes, my lord. Secondary. Yes, sir.
Is that the case out here? This what he's referring to?
Yes, my lord. Durjoy Paul, one writ appeal was my lord, filed before the division bench. That was subsequently infractions, my lord.
No, that
Yes.
one. Those matters pertaining to. Is that the matter pertaining to?
By acquiring
There's a
B.Ed.
direction that if a person completes the B.Ed degree from a recognized college and prior to 3/7/2012,
Yes, my lord. That is the case. My
is that the case? So I passed similar orders. We'll take it up then.
lord. Obliged, sir.
I hope it is same.
Yes, my lord.
Next.
Which item 26.
Yes. You want an adjournment?
Yes, sir.
Fantastic. Item number 26, at the request of the petitioner, matter stands adjourned for 4 weeks.
My lord, family pension matter, my lord. As it has not been listed after 21, my lord, 23, my lord. So matter may come subject to any date. My lord.
Go before the registry.
But I have already submitted, my lord.
Then nothing is happening.
Yes, my lord, that's why. Any date, my last week of the June also.
Last week of June.
Others may not be listed. Otherwise, covered case, my lord. Sanjita Roy.
Huh?
Sanjita Roy covered case.
Covered by what?
Sanjita Roy was saying that 6 years deduction, that type of case.
They are master rule.
Master rule.
6 years deduction.
Yes, ma'am.
In which department?
Irrigation department.
Rita Roy is irrigation.
Now that was different, but that judgment will also cover this.
Okay, we'll have it on 12th of June.
All right.
Yes, Mr. Solia. Yes, what do you want?
Filed an affidavit on 15/5, madam. That was not record, madam. Submit my office.
Lordship may go through I have a declaration from the petitioner, my lords, which I want to place on record. Lordship may just go through the record, this declaration, my lords.
Yes, but it's a very serious
Yes,
allegation
my
you have
lords.
made.
On the basis,
Serious allegation is a very serious thing. Now you have put an affidavit also, which means it will have more dire consequences if it is false.
so this is the declaration of the petitioner. my
I,
lords.
so and so retired headmaster, have drawn the gratuity and final pension arrear against so and so today on 19/4 form Nahar Kotia Treasury. 19/4. Then what remains?
Monthly salary notice, monthly pension notice.
Huh?
Monthly pension notice.
What monthly pension? You are getting the final pension arrear. You have already gotten and you are going to get the monthly pension.
Yes, my lord. That is,
Then nothing remains. Withdraw it just for the sake of it. Don't come up with all these things. I'm very strict on giving liberty. I don't give the liberty just for the sake of giving liberty. Withdraw. Simple. Heard Mr. K. Kolita, the learned counsel for the petitioner. Mr. A. Solia appears on behalf of the Treasury Officer Nahar Kotia. And Mr. P. Hazarika appears on behalf of the respondent number 4. So, taking into account that the petitioner have already withdrawn the gratuity and final pension area on 19/4/2023, the petitioner is not inclined to further press the instant petition. Accordingly, the petition stands dismissed on withdrawal. Before parting with the record, this court makes it clear that the Treasury Officer Nahar Kotia shall ensure that the petitioner gets his regular pension.
God bless.
Please, your lordship.
Yes.
My lord, the petitioner is aggrieved by page number 75.
Page,
75, my lord.
what is the case about? What are you asking for?
My lord, the
You have been
petitioner has
suspended.
imposed with the page number 75, the relevant part, your lordship will
Putting
kindly take
aside
it,
the
page
inquiry
77.
report on hearing the petitioner held on 20, the letter dated so and so, yeah. What is this inquiry report
My
about?
lord, this inquiry report is pursuant to a hearing that was held on 21/2021.
Let us see the inquiry report,
My lord, this is the inquiry report, page number 75.
75.
75. Now, in the inquiry report, my lord, the finding and the conclusion that has been drawn,
Inquiry report on hearing against so and so under suspension, so and so under Kachar in pursuance to so and so. Who is the inquiry officer?
my lord, the inquiry officer was the Deputy Director of Elementary Education, and the presenting officer was the District Elementary
Okay,
Education. Officer.
now what has happened? The
Now,
DO may be
like
instructed to
Lordship kindly sees
recover
the
1,18,000 from the salary.
My lord.
Okay, then what is your problem?
And one increment held up without cumulative effect. These are the two penalties imposed. Now,
Hmm.
your lordship will kindly allow me to just concisely place the backdrop of the case.
Hmm.
The petitioner, my lord, was the headmaster.
Understood.
My lord.
Thereafter, what happened?
My lord,
This is the
thereafter,
inquiry report. After that,
my lord,
what happened?
after this inquiry report, along with an order that the order dated 7/2/2023 at page 82.
Hmm.
My lord, this
With reference, I am
was issued by
enclosed a
the
copy of the inquiry report on hearing against so and so. During the inquiry, the inquiry suggested so and so. You are requested to submit a detailed report by following the suggestion of the Iman. This is given to the district
to-
Kachar so and so by the director.
Yes,
Then-
and pursuant to this, my lord, page number 84, this has been communicated to
Regarding
me.
recovery of so and so is delivered, required to recover from the month of Iman. So your basic case is ECIL. Who is the disciplinary authority?
My lord, the disciplinary authority, my lord, your lordship sees the decision has been taken
By whom?
by the respondent number 2. Respondent number 2,
Disciplinary authority is who? Director of?
elementary education, man.
So so you have been penalized out there without giving you an opportunity.
My lord, in fact, the opportunity that was provided that
Ah.
did not contain these issues. Your lordship will kindly, my lord,
No.
my lord,
Against, there is an inquiry report
my lord,
by an officer who is other than the disciplinary authority.
my lord.
Now pursuant to that, whether you have been show cause as regards the inquiry report,
My lord, in regard to the inquiry report, I have not been given any show cause direct penalty.
that has not been done.
That has not been done.
Fantastic. Now, now what are you challenging the inquiry report?
I am challenging the inquiry report
Eh.
and the decisions that have been conveyed thereafter pursuant to this inquiry.
So your basic case is that you have not been allowed the permission or given the opportunity of show cause.
Exactly, but I prefer the representation. In the representation, I made things clear. I even
Now,
submitted.
did they issue you
No, my lord.
a show cause
This inquiry report and subsequently these two letters that your lordship has just
at
taken
page
note of,
84?
82 and 84.
So
Yes,
that was done
that
without
was
giving you an
without
opportunity.
without any opportunity to.
So
check.
we will look into that and then allow your petition.
But
By not setting aside the inquiry, the only setting aside this, giving them the opportunity to take the appropriate steps.
my lord,
That is the better.
yes, my lord.
Keeping this matter, that day I got a matter of 2012.
Yes, my lord.
Then in 2012 and now in 2023, this only
Yes,
simple
Lord.
order is being passed. By the time that person have already died.
And my lord, the penalties which have been imposed, these are so redundant. There is a penalty for recovery of an amount that your lordship has seen. Now that amount has been utilized for,
I am not,
my lord,
Mr. D. Chakraborty, I am not on all those things.
My
If
lord.
you want to go into the question of facts, then I will say why you have not gone into appeal.
my lord,
Did you go and
my
appeal?
lord, that aspect, my lord. I'm
You
not
want to do
venturing
that?
in. I'm not venturing in.
Don't venture into all. Will those. Heard Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Attorney appears on behalf of the respondent numbers 1, 2,
2, 4, 5, 6,
4,
and 7. my
5,
lord.
6, and 7.
And for
Mr. S. Roy appears for the respondent number 3. The instant petition has been filed challenging the inquiry report dated
21/2020.
where? 21/2021. As well as the order dated 3/3/33.
7/2 and 3/3.
What is 7/2? 7/2 is
7/2
not an order against you.
That is, my lord, that is containing the,
This is a direction
Well,
to so and so. This
well.
has no, you are requested to submit a detailed reply following up the suggestion of the inquiry held on here. This is only asking for a report.
well, 3/3.
as well as 3/3/2023. Issued by the in charge block elementary education officer. Is that? Block elementary education officer who? Also, Katigora. Katigora district. Katigora. P.O. Hilary. Huh? Hilara. Good stuff. I think we'll issue notice, short notice, just find out as to whether this has been done.
Whether is there any so cause, my lord?
If there is no so called, the matter is against. Issue notice, making it returnable by when? Not long.
Within 1 week, I can obtain instruction, my lord.
Days, 23rd, no. 17th. We have it on 26th of May.
Yes, my lord.
Issue notice making it returnable on 26th of May 2023. As the respondents are duly represented, extra copies of the writ petition be served upon the respondents, the learned counsels representing the respondents during the course of the day. The case of the petitioner herein is that an inquiry was held against him in terms with the Assam Service Discipline and Appeal Rules 1964. And pursuant thereto, the inquiry report was submitted on 21/2021. On the basis of the said inquiry report so submitted, the Director of Elementary Education had issued a communication on 7th of February 2023 to the District Elementary Education Officer Kachar to submit a detailed report and suggestion in respect to the inquiry committee held on 21/2021 for taking further necessary action in that regard. On the basis of the said communication so issued, the Block Elementary Education Officer, Katigora, P.O. Hilara, had issued a communication dated 3/3/2023 to the petitioner, intimating him that the amount of 1,18,800 shall be recovered from his monthly salary at the rate of 50% of the net salary, and one increment has been held up without cumulative effect as per rule. It is the specific case of the petitioner that in terms with the judgment of the Supreme Court in the case of the Director ECI versus so-and-so reported in so-and-so, the petitioner has a right to represent upon being show caused by the disciplinary authority against the inquiry report. However, the same having not been done, it is therefore the case of the petitioner that the impugned order dated 3/3/2023 needs to be interfered with. The learned counsel appearing on behalf of the Elementary Education Department shall apprise this court on the next date, returnable date, as to whether any show cause has been issued to the petitioner pursuant to the inquiry report giving him a copy, thereby serving him a copy of the inquiry report and asking him, and so to show cause as to why action should not be taken in pursuance to the inquiry report. The learned.
My lord.
My lord will also issue notice on my interim period. I'm not insisting for it.
Don't insist.
My lord.
We'll dispose it out on 26th.
Okay.
Note 3.
Yes, Mr.
So
Bora.
Lordship, because of the ROP has come into effect, 2017 on 1/4/2016.
Which ROP?
2017 ROP, my lord, it has come into effect on
1/1/2016.
And
Then?
that area has not been released, my area, the salary has not been released, that ROP. And in the meantime, the petitioner has
Area
retired.
have not been
Not-
released.
In the
To
meantime,
whom?
petitioner has retired. And at this stage, I'm only praying for notice, my lord, that let them respond to the,
Clear the dues as per the revised plans. It's on attaining the date of superannuation when thereby reduced. Okay. So you retired only on 31/3/2021. And the ROP was released. Now
This went
tell
into
me-
effect from 1/4/2016.
No,
and they
understood
have
very
adopted
well.
it. But
Now
no,
tell me whether the ROP has been extended to this housing
They have,
board.
yes, they have adopted it.
Where is that
and-
document?
And I have made a
That is the
statement.
most pertinent
No, no,
document.
I have stated they have adopted it and the person who are apparently
They
employed.
can't adopt it. The government has to give it.
So government has, board has adopted it and the other employees are getting it. The person who are presently working, they are getting it.
Did you get it at the time of your salary
No,
retirement?
only on the service book, they made an entry and they have not.
Then where is the copy of your service book?
I have the service book, they are not, what the service book, that photocopy and even photocopy. I have made a statement, my entry are there in the service.
No, but then also, first and foremost, where is the adoption?
Well, I have made a statement, they have adopted it and they are releasing it for the person who are currently working. Only those retired person, they are not, they are constantly giving representation, they are not giving it.
The retired
for-
person, when did they adopt it?
Immediately after the 2017 month. They have adopted it after that 2017 and they have made entry in my service book also. They have made it.
How do you know that
Well,
they have
because-
entered in the service book?
They have seen it, but they are not, they are even tried to get a photocopy of the service book. That not-
You
not-
have retired on 31/3/2021.
Twenty-one.
You don't have a copy of the service book?
They are not releasing it. That Malas housing board it will not get anything, my lord. Unless there is a repetition, when even gratuity was not released, they have come before the
Is
court.
that the state of affairs in the housing board?
Lordship, my Lordship,
Huh? Too sad.
Lordship.
What he is saying, is that the state of affairs in the housing board?
I have come earlier, my lord. For my gratuity and all these things. Only after the order, they are getting it in installment basis.
Oh, that matter. Where I have given this check,
Yes, yes, my.
Yes, Lord.
that matter.
But that is not the same department.
Same matter,
board,
Lord.
my lord.
Earlier death matter, it is not, but similar matter, Lord.
Not similar, my lord. Even gratuity, I am not getting it in. I have get it
No,
take it
yeah.
in installment. Gratuity, CPF, management,
We have been
even
paying.
encashment. All we are taking in installment basis.
Heard Mr. S. Bora, the learned counsel appearing on behalf of the petitioner. Yes, your name?
T.R. Gogoi, Lordship.
E.R. Gogoi appears on behalf of the respondent number 1, 2, and 3.
Lordship.
Notice making it returnable when?
Actually, at least 2 weeks or something, the time may be required, Lordship. As because of instruction is required, Lordship.
I only require instruction. I don't require anything. Notice making it returnable on 9th of June. As the respondents are duly represented, the petitioner is directed to serve extra copies of the petition during the course of the day. The case of the petitioner herein is that the petitioner although had retired on 31/3/2021, And the Assam State Housing Board, having already adopted the Assam Service Revision of Pay Rules 2017, the benefit of the Assam Service Revision of Pay Rules 2017, however, have not been extended to the petitioner, although similarly situated persons have been granted similar reliefs.
But
You just
person
say,
who are working, they are getting that relief. Not
you
the-
were also working. You were also working then.
That time it was not,
Did you get your salary
No.
as per that?
no.
Then you only
Now-
retired
now-
in
now they are getting
2020. Therefore, my specific question was, when did they adopt? You are saying in 2017.
2017 service, it was adopted. They are also not getting it, but now they have started getting it. The person who
When?
are working. On the exact date, I don't know, my
So
lord.
that is the most relevant thing. You find out. You don't otherwise have a case.
My lord, persons who are working, they are getting it.
See, Assam ROP categorically mentions that it will not cover all other persons except those people who come within the affairs of the government of Assam.
Yes.
These people don't come.
Board has that. My lord, the board have to adopt it.
Not only that, if it is a government of Assam has any stake out there, the government has to extend it also. Without extending it, how can a person adopt it?
But
That
I
is
mean-
the problem, right and left and center.
my lord, let him get the instruction. Others are getting it, my lord. The person who are working.
So you want this court to make this court a fishing and roving
No, my lord,
inquiry?
that not. Only said that the
You don't,
instruction.
otherwise you have not been able to make out a case.
I've already.
Last line. Please. On the other hand, Mr. T. Agogoi, the learned counsel appearing on behalf of the respondent number 1, 2, and 3 submitted that he has to take instruction as to when the Assam Service Revision of Pay Rules 2017 have been extended to the Housing Board by the government and adopted by the Housing Board, by the respondent board. Taking into account the same, let the matter be on the returnable date, Mr. T.R. Gogoi, the learned counsel, shall apprise this court as to when the Assam ROP rules of 2017 was extended by the government and when it was adopted by the Housing Board.
Item 4.
Exactly similar, my lord. Only retirement date is different. Retirement date is different.
Same.
Same, my lord. Retirement date is different.
Retirement date is what?
Retirement date is 31/3/20.
20. 31/3/20. I go to 21.
That's it.
It is 20.
Mass of this.
Five.
Hey, but the petitioner, my lord, over, my lord. January 1993, my lord, is a senior worker, the forest department, my lord. But my lord, the petitioner could not, my lord, produce, my lord, voucher of that time. However, voucher of 1997 June available. My lord,
When did the petitioner join?
my lord, 1/1/1993, my lord.
Huh?
1/1/1993, my lord.
Are you getting your minimum scale of pay?
Oh, my lord, this is my lord, I am not getting, my lord. And my lord, authority is supporting my case that I am working, my lord.
But why you asking from earlier period from 12, shall not be paid his fixed pay from 23/1/2001 as revised from time to time and to pay the minimum of the scale from as per the direction.
Because
You
my
have not
lord,
got your fixed pay.
2001 I got, I received. Thereafter my lord stopped,
And you have been still working.
my lord.
My goodness.
Yes,
Are
my
you a
lord.
teacher?
No, my lord, casual worker, my lord, the forest department.
Casual worker in the forest department, you are working for the last 22 years and have not done anything. And how are you surviving? Give us a good reason how. How is he bearing expenses for a lawyer? Tell me. A person who has not got a salary for 22 years. Yes. You tell me. How is it possible? Mr. Solia, you are from the finance. Tell me. How is it possible for a person who has not got a single penny for the last 22 years? Is it possible? Huh, Mr. Sohan? Is it possible?
Lord, he is a parasite, my lord, on the family members.
And why have you approached now?
But my lord, earlier he approached my lord. My lord, this honorable court, my lord, directed to
When?
consider, my lord, page 41. My lord, to consider my case as per para 22 of Upenda's case.
Then
Then, my lord, it was not considered. Thereafter, my lord, one contempt was filed. In the contempt, my lord, they, my lord, submitted one, my lord, minute dated, which is, my lord, at page 55. It was not supplied to me earlier, but in the contempt they supplied me. And they says that, my lord, prior to 1/4/1993, no, my lord, document, casebook or voucher, my lord, available. That is why my case was not, my lord, considered for regularization, my lord. My name is, my lord, at page 56, serial number 12.
on the basis of the documents furnished by the has recommended the names of 11 numbers of left out casual workers out of the exit on it. As such, 11 numbers of left out they are recommended for consideration as fixed pay. Yes, your name is there. Then
Name is there, my lord, but my lord, contention of the higher authority is that, my lord, prior to 1997, no voucher or no casebook record found. That is why my case for regulation was not considered. But, my lord, why they are not paying my minimum sale? They are silent, my lord. Authority is silent.
so your case was recommended.
Not recommended, my lord.
Was considered, Your Lordship.
Huh?
It was put before the committee. It was considered as per page 57. It was not recommended because there was no supporting documents for the petitioner, Your Lordship.
No supporting documents as mentioned in the performer at column number 11 were produced by the DFO. Therefore, the committee does not recommend their names. So fixed pay, this was not recommended. Are you challenging this, the order?
My lord. My lord, yes.
Then,
My lord, kindly see page 59, my lord. This chairman himself wrote a letter to the my lord government, page 57 and lecture 13, my lord.
no, then there is a, after this was written to whom? To the so-and-so repetition of so-and-so, 2019. Record furnished by Joe has been cross-checked with the performer Iman and it appears from the following that Soya was working from 1990, but no records as per prescribed or in Iman is available except cash book of so-and-so. In view of the above, has no supporting document as so-and-so. Then there is an order passed in 2019.
Yes. My lord, page 59, my lord. This my detailed case has been submitted by additional PCCA to the government, my lord. Page 59, here, 13.
Submit a report. Then what has been done?
Here, my lord, government, my lord, by order dated, my lord, 2nd May 1919, my lord, page 60, my lord, written to re-verify my case, page 60, my lord. But what happened thereafter, not known. My
Chief Secretary. So there is a direction being given and that there is a request being made that your case should be regularized. Only come to Annexure 18, page 66. So this is somebody else. Sanjay Das. Yes, you are Sanjay Das. I've been working for the last more than 10 years prior to the judgment, and presently he has been working in the Sadar range so-and-so as per the report of so-and-so for your kind info. Then what have you done? And what has happened to the contempt case?
That has been closed, your lordship. That has been closed.
The order
Why?
is annexed, my lord.
Order is annexed.
Page number 85, my lord.
lord, it was closed because of that, my lord, minute. My lord, page
This case was
86,
rejected, my lord.
page 86.
The basis of the minutes, your lordship. This case was
Priority was
rejected.
given to approach, challenge.
Okay. So contempt goes.
My lord.
Now
My
therefore,
lord, my prayer, my lord, depending on my lord, para 22 to open this case, my lord, where my lord, honorable court, my lord, and government also submitted that they will not terminate it, who has been working since last 10 years. And my lord, this honorable division bench, my lord, said that, my lord,
no. Yes, you are forest.
Yes, your lordship.
What action has been taken pursuant to Annexure 18, page 66?
And this was regarding the contempt case, your lordship.
Maybe, but there was a request.
Yes, but
Contempt case was closed because of the fact that there was a direction for consideration.
yes, your lordship.
You have considered it.
Yes, your lordship.
And in out there, you find that there are certain documents which are not available.
Yes, your lordship.
But the fact that it is an admitted fact to the effect that the petitioner have been working for last so many years, and also that he has been working out there so-and-so for more than 10 years
Yes, your lordship.
in the casual employment out there of the year, would he not be entitled to the benefit of Upendas?
May I take your lordship to Annexure 18, page 59, your lordship.
Page?
Annexure 13, page 59. Page 59, your lordship.
Yes.
My lord, this was
This was in 2019.
19, your lordship.
Yes.
They have given a reason for not, since there was no supporting document, the case cannot be
This
recommended.
is for the purpose of fixed pay. As to whether he is entitled for the purpose of fixed. But it is an admitted fact from these government, from the office of the principal chief conservator of forest,
Yes.
who is the head of your department, who says that yes, the petition is otherwise entitled to Upendas. Isn't it? That is of 2000. You are referring to 2019. I am saying about 2022. Mr. Chauhan, you may not be entitled to the fixed pay, but you are entitled to the minimum scale of pay as per Upenda. Although your prayer is more elaborate, containing many things. so that nothing is left out except the moon. But otherwise, your basic claim is the minimum scale of.
My lord.
Heard, Mr. You get your instructions
sir.
when?
Lordship, after 2 weeks, your lordship.
It is, my lord, my interim prayer, my lord, at least, my lord, to survive, my lord, my current, my lord, fixed pay at least. Pay.
Heard, Mr. S. Chauhan, the learned counsel appearing on behalf of the petitioner. Mr.
RR Gogoi, your lordship.
R.R. Gogoi appears on behalf of.
Respondent number 1, 2, 3, 4, 5, 6, and 7.
1 to 7.
Yes, your
Mr.
lordship.
A. Solia appears on behalf of the respondent number 8, making it return on 23rd of June 2023. As the respondents are duly represented, extra copies of the petition be served upon him by 19th of May 2023. The case of the petitioner herein. Now, from a perusal of the writ petition, it transpires that this is the second round of litigation filed by the petitioner. In the initial round of litigation, the petitioner claimed for the benefit of the directions passed by the division bench of this court in the case of the state of Assam versus Upendas, dated 8/6/2017.
They came for regularization, my lords. And the honorable court gave us a direction, gave the respondents a direction to consider on the basis of open document. They were claiming regularization, which was rejected, my lord.
This is the second round of litigation.
So on the first round of litigation, they did not claim for arrears salary, my lords. The first.
First line too. This is the second round of litigation. In the initial litigation, that is WPC number 6870/2017. Though the petitioner claimed regularization of his service, but this court, by the judgment order dated 13/11/2017, directed the state respondents to consider the case of the petitioner in terms with paragraph number 22 of the judgment of the division bench of this court in the case of state of Assam versus Upendas, dated 8/6/2017, isn't it?
Yes, lordship. 8/6/2017.
8/6/2017. It, however, appears that pursuant thereto, there were steps taken for consideration of the case of the petitioner. It further appears from the minutes of the meeting held on
6/8/2018, your lordship.
6/8/2018, that though the petitioner name was recommended, though the petitioner's name was recommended for consideration as fixed pay workers, but though the name of the petitioner was recommended for consideration as fixed pay workers by the DFO Karimganj division, but the committee did not recommend the name of the petitioner on the ground of there being no supporting documents. Be that as it may, on the basis of the recommendations made by the committee on 6/8/2018, the government of Assam, the secretary to the government of Assam Environment and Forest Department directed the PCCF and HOFF Assam to re-verify the records and submit a report to the department within 30 days from for further action. It further appears that pursuant thereto, the range officer forest, range forest officer Sodor, range Karimganj, as well as the additional PCCF, bracket administration and vigilance, bracket close, have issued communications to the authorities concerned that the petitioner is entitled to the benefit of noting therein the entitlement of the petitioner in terms with the judgment of the division bench of this court in Upendas Supra. The learned counsel appearing on behalf of the Forest Department shall apprise this court on the next occasion, next date, on the returnable date, as to what steps have been taken pursuant thereto. Pursuant to Annexure 17 and 18 of the writ petition.
Number 7 for admission.
It is a lordship.
Yes, what type of teacher you are? Illegal.
So whether we are not recommended but still working. But unfortunately, I have retired on what has happened in this case. 5 petitioners were there. Out of that, 4 have already joined services as per the new arrangement which has been made by the government. So only remain is petitioner number 5. And she has retired on 31st December 2020. The scheme has come on 30th January 2021. The scheme.
When did she retire?
30th December 2020.
2020. Okay, the scheme came into effect. Which scheme? That one?
Yes, my lord.
That one.
The scheme came into effect on 7/10/2020.
No, but nothing has been communicated to us. The recommendation of the department came on 30th January 2020. That is by instruction. Now, lordship, in this case, but anyway, we have not availed the scheme, lordship, because of the fact that
All the petitioners did not avail.
My stand is that the petition number 5 stand is that, lordship, that whatever I have been legally appointed, I have been working and I have retired. So my salary has to.
Fantastic. Now you have retired. You must have been given a superannuation notice.
Lordship, that has not been given, has not been provided to me.
You were appointed by whom?
By the department, lordship.
Show me your appointment letter.
My lord, what has happened in this case, my lord? All the 5 petitioners were there. So individual appointment letters were not given, lordship.
Your basic case is your appointment letter. Where is your appointment letter?
Lordship, I have this. Has not been annexed, my lord, but I have this with me.
What?
The appointment letter, because that time while filing this case, total 5 petitioners were together.
No. Mr. Deka,
My lord.
kindly appreciate one thing.
Yes, my lord.
I hope you know the history about these matters.
I don't know.
Fantastic. Then I don't need to repeat. Pursuant to in 2010, there was a direction given. For there, a screening committee was formed. In the screening committee, you did not come in category number 1,
No,
neither in 2,
not into
because you are still working, you were saying.
Yes.
So you can't come in 2.
3, lord.
So you came under 3. So the screening committee found out that your appointment was illegal.
Lordship.
There is already a verification of facts being already made by an authority who can verify. So you come within the ambit of 8,470 teachers.
Yes, sir.
Pursuant thereto, the government took a decision that they will further characterize those persons who have already got their salary till 2007, having the qualification, those who have not got the salary, but who have got the salary but no qualification, and the third is who have not got anything. Now, 4 of the petitioners have been appointed as tutors. This was being done by the government, irrespective of illegal or irregular. We are doing so only as a one-time measure to that effect.
But my lord, I was not appointed as a tutor, as a teacher.
Fantastic.
So my,
Understood. But you have been appointed as a teacher, but the fact that you're teaching, your appointment was illegal or irregular is a fact which has already been settled by the screening committee.
my lord.
The matter ends. This court should issue a writ?
Just, regard to this one.
Because this court will be empowered to issue a writ only if you have a legal appointment. I make it very clear.
That is the basic.
And the fact-finding inquiry has found out your appointment to be illegal.
No, my lord, the only thing what why I have mentioned this matter to be listed to. What is the thing is that matter? Whatever is being said is only in the air, Lord. There is no affidavit file in this case. Nothing. Whatever I have got from the department, that is what I'm submitting. Now I'm in a hangman. I have nothing has been given officially to me. Nothing is there in office. So in this regard, if I am not recommended, nothing has been stated in this petition. I went to the office, I found out what has happened, and then I'm submitting. The reason I have mentioned this matter.
No, the fact that you have mentioned out there, if it appears out there, teacher's appointment verification system,
Yes, my lord.
your name was appearing out there.
Yes, my lord.
Okay.
Yes, my lord.
Now, in this verification system, what happened out there? What was found out?
I have been working, my lord.
No, working, you see, the earlier matter also, Mr.
But-
Chauhan's client was working for the last 23 years.
Yes, my lord.
But does it make his appointment legal?
Yes, Lord. For that, in that point, my lord, I will place all my appointment letters, everything which I have placed before a screening committee, my lord, on the next day. Everything is there with me. But everything is there with me.
Why haven't you done so? It's a whole matter.
So that time the things were in a different direction, my lord. All the cases were taken up together, and
Who?
this
No, that was segregated. And I have, in the first list, out of these, I've disposed of half of it, isn't it?
yes, my lord. And my lord, on top of that, my lord, the 4 of the writ petitioners were together.
That day, that matter, na, Junu Devi,
Das.
Junu Das. Have a look at the judgment. I've detailed out how it is, and the right to salary will be dependent upon a valid appointment
My lord. I'll satisfy.
for this court to pass. But it is not apparent.
My lord, my lord,
Now
I
you
will
want to file an additional affidavit.
additional affidavit, and my lord, and with regard to that is my prayer, my lord. I want to amend the prayer also, because since the petitioners have left, only 5 is there. So, my lord, the entire session in one. I will amend the prayer to that effect, and also the written, and bring all these on record. Only then when I will be entitled to relief. Otherwise, I will not.
No, but Mr. This is a matter of 2017.
But kindly grant me 2 weeks time, my lord. Then
Didn't you know what has happened? When did the petitioner retire, you say? On 2021,
2020, my lord. December 20.
2020. What were you doing for the last 3 years?
So, my lord, what has happened, my lord? Categorically, my lord, the petitioner is the
Mr. Dekha, you have to be, should see that this court never grants an adjournment of this bypass. You better do one thing. Let me dismiss it. Go in writ appeal. File all those documents there. Isn't it?
No, my lord, that's
Better off. Not to do all this.
No, my lord,
You are, first of all, there is nothing on record to show that you have been legally appointed.
no, my lord, my lord, I have been, my lord, all these appointment letters are with me, my lord. Let me give a chance to file these.
Show me appointment letters. Now, when the fact-finding inquiry have already not given you the regularization, That means your appointment is illegal or irregular. So then it becomes within the ambit of the government to either regularize or give appointment. Now it is difficult to find out.
No, it is there, my lord.
Give it to me. What do you mean by this? Jila Prathamik Shikha Bikoya? Who is he?
District Elementary Education Officer.
See? Show me any provision that district elementary officer is have the authority to appoint?
This is also to RTI.
Huh? What is this?
To RTI, my lord, I have obtained, my lord,
What is that?
the list, my lord.
This is already enclosed. This RTI, what you have obtained is what?
The list of teachers, my lord, legally appointed teachers, my lord.
Legally appointed teachers.
my lord.
Are you not aware? This document forms a part of your petition at page 24.
So, my lord, this is there, my lord, but this has been given after the RTI has been given, my lord.
So why are you showing me this document when it is already there in the petition?
Paragraph number 4, annexure number 4, yes, lord.
Yes. Why are you showing me this document? It's already there in the petition. See? Appointments, constituency. As revealed from the result sheet, so-and-so is declared by the Dibrugarh to have passed in the pre-degree arts examination. The mark sheet has not been received. 99, this is an appointment to whom? Mr. Counsel, what are these appointments? 26/2014.
That is
ইয়াৰ
just the
দ্বাৰা
appointment
আপোনাক
letter.
জনোৱা হয় যে ইংৰাজী ইমান 2014 তাৰিখৰ যিমান স্থানত সময়ত so this is for verification.
Verification.
So your appointment is not by the district, this is by SD Rahon. Doesn't it require signature? Are these appointment orders given in this manner? I've never seen all the while. It is not only in a cyclostyle, only the name has been put and there is no signature SD.
It has to be signed, my lord.
Then in pursuance to the government or subject to the approval of the so-and-so following of rationalization of their own grade and pay scale of so-and-so is hereby drawing his or her salaries as so-and-so. No case. No case.
So, my GPS has also been recorded, my lord.
That is why you have been given the teacher. This person has been given as teacher.
Teacher.
That is why he has been given because of the 2007. See, those people who have got their salary till 2007, that is why I say there were 4 categories of teachers made. One was the person who were duly appointed and were working. That is category 1. Second were those teachers who were recommended, but they were not in job, so they were not given. Third were the teachers who were illegal and or irregular, who were not recommended, but they were working. And the fourth were those teachers. Now these are comes, you came within the third category.
My humble submission.
And that is why you have been given with in terms with that teacher thing that you were appointed out there.
My humble submission.
Yes, tell me.
My lord,
Service book is also there.
yes, sir. My humble submission is that after this has happened, man, I may be allowed to challenge that order of the screening. Because if the recommendation of the screening committee will not be challenged, I will probably not have a case, man. So, my lord,
No, it is a fact-finding inquiry by them.
yes, my lord.
You are to challenge it.
Yes, my lord.
Wherever you challenge it.
That is the reason why, my lord.
No, if you don't challenge it, then it is your lookout. But how can this court decide that?
That is the reason why, my lord. That is
Go
the-
to the civil court. Go to the civil court, fight it out.
My lord, I have already retired, my lord.
You are already there in the civil court.
I have already retired, my lord.
So
My
retired
life
also
is
if you
over,
want
my
your money.
Now civil.
ঘুরাই দিও কাগজ আকৌ heard Mr. P. Deka, the Learned Counsel appearing on behalf of the petitioner. Mr. N.J. Khatonia appears on behalf of the respondents.
Elementary education.
Elementary. It appears on the record that there is no affidavit so filed by the Elementary Education Department. Be that as it may, the Learned Counsel for the Elementary Education Department is given a final opportunity to bring instructions as to what was the finding of the screening committee in respect to the case of the petitioner, in respect to the petitioners, and what
Petition number 5.
actions have been taken pursuant to such finding insofar as the petitioners are concerned. It further appears from the reports that although there are 5 writ petitioners, there is only the court fee of only 1 writ petitioner has been paid. Considering the above, as the rights and claims of the petitioners are separate and distinct, each writ petitioner has to pay separate court fee. Are you willing or not?
My lord.
Are you willing or not to pay the separate court fee?
4 of them have already.
Are you willing or not?
Yes, my lord.
Mr. P. Decker, Learned Counsel for the petitioner, submits that she shall do the need or not before the need. Is the matter again on how much?
3 weeks, man.
12th of June. Do whatever.
Obliged.
I love it.
Eight.
My lord, I'm appearing on behalf of Ms. MD Bora. My lord, we could not mention the matter because we could not contact the petitioners. We have filed our affidavit. But the petitioners are not present.
So on the last occasion, he had mentioned that there is some order being passed.
My lord,
You have the copy? Yeah.
sir, it's in the
B file, it's in the B file. The B file.
Who has filed it? Oh. Yes. What is this the petitioner is asking for?
She's asking for the pension of her husband. My husband has passed away.
The petitioner has not appeared on the last occasion also. Maybe the petitioner must have got it.
I'm not aware, ma'am.
Okay, none appears on behalf of the on call. Miss, your name?
R.D. Goswami.
Abhi Goswami appears on behalf of the
Ms. MD Bora, Corporation Department.
Corporation Department. You are paying?
For this lordship pension, for pension.
The CS Hazarika appears on behalf of the Director of Pension. The Arbor Bhutari appears for the Finance Department.
And that I don't cause any harassment and mis- Some other bit- Petitioner's case is then whether this seeking declaration from this honorable court that his past services be counted for the purpose of granting pension. In his pleaded cases, then similarly situated persons, in their case, the government had invoked the provision of Rule 31, thereby declaring that the past services be counted. This is precisely the case.
So, in terms with the proviso to Rule 31, the governor has given a declaration in those.
That is what he pleads. Petitioner pleads. For the petitioner to satisfy this honorable court.
But the petitioner is not here.
Yes.
So,
Take up this matter.
you want to satisfy for the petitioner? Well, this court is not going to dismiss the matter for default.
No, no,
This
no
court will
difficulty, no difficulty. Any
adjudicate
other
on the
day-
merits.
Yes,
It's a case of pension.
yes,
Other matters I will do it. Don't worry. When say appears, with-
obliged.
it's the matter of 2 weeks.
Nine to 22.
Yes, madam. What is this matter about?
If,
The book also.
Lordship, this matter relates to Lordship levy of marketing cess on the goods which are imported from outside the state of Assam. Lordship, in fact, similar matter, Lordship, having similar situation, Lordship is pending before the division bench of this honorable court in Assam Plywood Manufacturers Association. So I
So,
think the judgment of
Why did
this-
it go to the division bench?
Lordship, division bench, because in that Assam Plywood Manufacturers Association case, that time Lordship, section 21A was also in picture. Now 21A is no longer there.
Then,
Because
how is it relevant then?
no, Lordship, but section 21A, Lordship, they had challenged the validity of section 21A. That is why it went to the division bench. We have not challenged the validity of 21A because we filed the case after
So
the.
how is it relevant? The matter is before the division bench. So that is the reason there is a separate challenge to a provision of the act or the rules.
Along with that, Lordship, they have challenged that levy of marketing cess on the goods which are imported from outside the state of Assam. That there cannot be a levy on the goods imported from outside the state of Assam. That is the
Madam, you
question.
kindly understand one thing. The division bench jurisdiction and discourse jurisdiction is one and the same. Taking into account when there is a first challenge out there. Yes, when there is a challenge to a provision of law, it will definitely go to the division bench.
Yes, yes.
But if it is a case where this, as regards a challenge to a levy, this court's jurisdiction and the division bench jurisdiction is one and the same.
Yes, yes.
It's only when an appeal is being filed out there, then the question would have been different. Otherwise, it is one and the same. I'm not bothered whether the matter is pending before the division bench, unless it is different matter. But tell me, what is this case about?
Lordship,
Oh, there is a written argument also.
Lordship, actually, in this case was heard at one point of time. Lordship, this case was heard. We both have filed our written argument. Lordship, in fact, these cases have been heard twice. One by Lordship Justice. Lordship, one by Justice N. Koteshwar Singh.
So you want to go to Jammu and Kashmir? Fantastic.
Lordship, actually, in fact, it was CAV, and only the judgment was about to be passed. But thereafter, on the day when the judgment was about to be passed, that day itself, Lordship was elevated to Jammu and Kashmir.
Now tell me, what is your case?
Lordship, may I pray one thing, Lordship? Lordship, today I'm not that much prepared. It may,
Also,
any
will
other
hear
day
now.
it may be fixed.
Also,
I
in
don't
this
give
case,
a
there are
adjournments
alternate
for this
remedies
thing.
there, Lordship.
Huh?
Alternate remedies there, Lordship, in the act, Lordship. But they have not gone to the alternate remedy. And Honorable Apex already disposed of the contempt case wherein it stated that they may approach before the committee for their grievances.
Mr. Counsel, we will go into that. First, let me know what is the case.
Absolutely.
about. Yes, tell me what is the case. Then only we can go to any. We'll see about alternative remedy later.
Lordship, I'll just give a small brief, Lordship, so that the
Hmm.
matter can be heard today. But Lordship, I would pray that
No,
I'm not much
no, the
prepared,
moment you
today.
give the brief,
Any date
then I will
fixed
go
for-
into the question of alternative remedy. Yes, tell me.
Lordship. Lordship, in this case, what had happened, Lordship? The petitioner, Lordship, Lordship brings the goods from the outside the state of Assam. These are, Lordship, subject to marketing cess, levy of marketing cess.
Now tell me, after this GST, whether the marketing cess is there?
Lordship, the marketing cess has gone away now. Now, after from 2020 to 2020.
Now,
Before
is there any demand there? Then why you are challenging now?
Lordship, because Lordship, what had happened because of the Farmers Act. Lordship, what had happened? The Farmers Act had come into being. So
Ah.
thereafter, they had stopped taking this
But,
one. But the,
oh, now, yes.
The farmers will have gone away, Lordship.
Miss Havelia, now I remember. There should be some order passed by this court also.
Yes, Your Lordship. Yes, Your Lordship.
Ah, yes.
On
Wait, wait,
22,
wait,
12,
wait, wait,
2021,
wait,
Lordship.
wait. I have some vacated some order, no?
Yes, Your Lordship. On 22, 12, 2021.
Yes, I have
Lordship, item
recorded.
number-
Now I remember. Yes.
Lordship,
Hey,
item
where
number-
I এখন file করেছিলাম লোকে কুম্বায় জন্য।
Lordship, it is item
Where is that
number-
order?
Lordship,
Now I remembered.
item
When you
number-
said about farmer thing.
Lordship,
Now
item
that
number
act
10.
is no longer there, the Farmers Act. I
So we have
remember
not collect
now.
any cess from 2020, let's say, 12 June.
Okay.
We have not collect any cess from the petitioners or any other from 12 June, let's say. There is a notification, let's say.
You give it to me. But where is that order which
Lordship,
I passed?
Lordship, item number 14, the order has been passed. Lordship.
Yes.
Lordship, the net is
Now
not
there I
working.
have taken into consideration what you have argued.
Yes, Your
And at
Lordship.
that time it was some COVID, you were there. with
Yes,
the
Your
TV.
Yes, Your
I
Lordship.
remember. Yes. Now I remember.
Item number 14.
Oh,
order has
I
been
thought I fixed it on 5th of December then. If
Yes,
I
Your
remember
Lordship.
correctly. It has not yet been disposed of.
Lordship, it was heard
was heard
three
by-
times by, Lordship,
So
the matter was
today-
finally heard.
Today is the final date. Oh, I'll tell you. First and foremost, after this
Yes, Your
limits, the imposition,
Lordship.
they say that 12th of
12th of June.
they are collecting.
2020.
Now, what we need?
Lordship, because Lordship, this, in this cases, Lordship, 22, 12, 2021, if the Lordship kindly see the order.
Hey,
In 13 or 14, Lordship.
have the copy.
Lordship, last 6 days, the site is not working. Otherwise, Lordship, I would have given copy.
You
22.
don't have a copy of that order?
In the Lordship, we have seen it in the morning. It is there in the record.
Okay, forgive me.
Item number 13.
Question.
10.
Repetition number?
Item number 10 also the order is.
Yes, at your behest, I vacated the interim order.
Lordship, it is in item number 13. The order is there. We have seen it in the morning.
Now tell me, what are you telling? What you?
They have collected the fund.
There is a levy and collection. First, there is full valid. Okay, so only one prayer remains. So that prayer remains. Now the collect will add. Then you end.
Then I'm entitled. Otherwise, no.
Okay. Hey, show me why is it bad. So farmers
only relating to lordship, other lordship administrative part. Only section 21 and 21A the collection of power to levy. Every market committee shall levy and collect a cess on the agricultural produce bought or sold the market area at a rate not exceed for every 100 rupees. The aggregate amount for us which has specified agricultural produce is bought or sold, whether for cash or for deferred payment or other valuable consideration. Assam State Agriculture Marketing Board shall also have the power to levy and collect cess for
So when
any or
it is
all of
brought or sold, so if it is bought also,
what are sold in the market
it has
area.
to be, there has to be a purchase or sell
Yes. At a
in the
rate of-
market area.
in the
And if I remember correctly, there was the entire state of Assam was made a market area.
yes, your lordship, it has been declared as a market. And if any buying and selling takes place in Delhi, lordship, the state of Assam is not concerned. It has to be the market area. That is the state of Assam.
So your case is if the transaction of buying or selling does not happen within the market area, the question of imposition of 2% of the taxes does not happen. That is the long and short case.
Long and short case, and lordship, my main contention is that after, at least after coming into effect of GST, from 2017 to 2020, they had collected. At least after coming into effect of GST, whatever has been collected should be refunded. Before that, lordship, because they have been collecting it after the judgment of the Supreme Court, they have been collecting it. Lordship, even at least after the GST period, whatever they have collected, that should be refunded.
Also, kindly have a look at the explanation of the section 20 on lordship.
21.
Section 20 on lordship. Section 3 lordship.
Explanation 1, lordship.
Explanation 1 lordship. For the
subclause three.
purpose
Subclause
of this section, all specified agricultural produce sell unless the contrary is proved, be deemed to be bought or sold in the notified market area. If one such produce is taken out or proposed to be taken out of
Understood.
the same
Everything is understood.
and then delivered.
No, but Mr. Counsel, tell me, how did you do it after 1/7/2017? What is the date of this?
2000.
Okay, after 1/7/2017, how did you do?
So there is an order from the government of Assam Irrigation Development Lordship. I have annexed in my affidavit lordship. When they stated that the normal realization of cess under section 21, Assam Irrigation produced market in 1972 on specified agricultural commodities from the market areas will continue. That is after a GST lordship.
Understood, but then also you have to have the power. Once this power has been taken away, whether, I don't know, is there any document to show that the cess under this is subsumed with the GST?
Lordship, it is lordship. I have got the lordship, the book, lordship. I don't know the book. In the Assam General Sales Tax Act and the Central GST Act, lordship, there is a preamble.
GST.
Yes, sir. Lordship, state Assam State GST.
GST. Yes, sir. That book is relevant. Why haven't you got it?
Lordship, actually,
No, don't expect this court. Always the matters happen on happening. And more particularly these series matters. I've been given the authority to finish up all these series matters as soon.
what I was proposing that lordship, lordship may kindly lordship reserve this matter for lordship part, may keep it this matter parted and fix it on 30th May.
I
Lordship,
don't
I'll come
require it
better
to be
prepared.
made parted. It will automatically come to me on
30th May.
where
Lordship.
in the CGST Act it has been mentioned.
Lordship, I have seen this as AGST Act, Lordship, CGST, where exactly where it is mentioned, I will be not be well, but Lordship, very clearly. Okay. All state cesses have been subsumed under GST. That has
State, Assam, what is that book?
Some Goods and Service Tax Act, Lordship, 2017. Even under the Lordship 101st Amendment to the Constitution of India, Lordship, that has been laid down.
State,
The 101st Lordship Amendment to the Constitution of India, Lordship, that printout
you are referring to Assam State GST Act, where schedule?
Lordship, may kindly give 101st Amendment to the Constitution of India. Printout.
Activities to be treated as supply, that probably. It is.
Printout. Lordship.
The Assam GST Act will only come when the question of the sale happens, buying and selling happens within the
Within the
state.
state of Assam. Yes, your Lordship.
Otherwise, anything else happens under the central state.
That will come into effect when buying and selling it comes. And Lordship, any buying and selling, anything, any cess or any tax relating to buying or selling of goods, that has been substituted to GST. That is the Lordship 101st Amendment to the Constitution of India that has been Lordship laid down. And Lordship, the copy of that has been Lordship Assam Goods and Service Tax Act that has been incorporated. CGST Act, Lordship, that is the.
It is there in it is available in the net.
Yes, your Lordship, it's available.
And you don't have a iPad? Appearing without an iPad also? If people
I
are
have an
tax
iPad,
lawyers, you
Lordship, I
don't
did
have
not
an
bring it to
iPad.
the court.
I'll take that into account.
Now tell me, are
Lordship,
you,
there are two notifications.
no, forget about the court's order. I'm asking you whether you have the power after the GST to collect taxes.
Lordship, there are two notifications issued by the Central Government of India Ministry of Finance. I have annexed in my affidavit, Lordship.
Where,
There are two
in which
notifications. After-
case you have filed affidavit?
in WBC number 1326/2020.
16
26.
affidavit filed.
Lordship, those are next to the writ petition also.
In my affidavit, running page 207 was annexed.
Affidavit filed by respondent number 2, 4, 5, and 6.
Lordship.
13th of March 2020.
Lordship.
Yes, what are you?
Page 55, running page 207.
Huh?
Page 55.
207.
207 running page.
Yes, control here.
Lordship, this notification issued by the Government of India Ministry of Finance on 20th June 27. Lordship.
Besides the purpose for the subsection 1.
Intrastate supply of service of prescription as specified in column 3 of the table below from so much of central act available thereon under subsection 1 of the section 9 of the said act as in excess the said tax calculated at the rate as specified in corresponding entry column 4 of the said table unless specified otherwise subject to the relevant conditions as specified in the corresponding entry in column 5 of the said table, namely is the table, Lordship. There in Lordship, page 219.
Huh?
Page 219, Lordship. Sorry,
Yes.
page 220.
Eight
54, page 220, Lordship.
services relating to cultivation of plants.
Cultivation service relating to cultivation of plants. After that, Lordship, as the Z, Lordship. Service by any agricultural produce marketing committee or board or services provided by a commission agent for sale or purchase of agricultural produce, Lordship.
So you are coming under G.
That's it. That's it. The definition of agricultural produce is mentioned in page number 226.
220.
6 running bit. There's a definition of agricultural produce. Roman D lost 2D lost definition. Agricultural produce means any produce out of cultivation of plants and rearing of all life from the animals except the rearing of horses for food, fiber, fuel, raw materials, or other similar products on which either no further processing is done or such processing is done as is usually done by a cultivator or producer which does not alter its essential characteristics but makes it marketable for primary market.
Lordship, this note 12/2017, which has been referred to.
So GST come in the year 2017.
So in terms with this notification of 2017, is
After that, another notification.
services
After that, another notification also issued.
where
And that is page 234.
some government.
Yes, Lordship. It is dated 29 June 2017, Lordship.
So now why you are not collecting now?
So as per the central, there is a notification issued on 12/6/2020. First, stop, Lordship. Again, new act will be come, Lordship. In report of explain, Lordship. Concern, Lordship.
So your case is that as this thing has been brought outside the scope of the CST and AGST Act, and therefore it would not, there is no bar for you to collect.
And Lordship, they being they in the petition, they admitted that they bought the commodities for the state of Assam for resale and manufacture. They for which they come with a definition of rule 2 to buyer, Lordship. And Assam State Agriculture Police Market Rule 21 to give the responsibility of the buyer for it a sales, Lordship. Lordship, first look the definition of buyer, Lordship. In the rule, Lordship. Second part is the rule, Lordship.
Where
Section
seller
2,
is there,
buyer.
buyer includes
Includes a person buying any agricultural produce himself or on behalf of any other person or organization or firm as its agent or as commission agent for resale. They being the commission for resale to the state of Assam from the outside of it is admitted, Lordship.
No, merely because he is a buyer. Does the activity of book and sold happen?
Yes, well, if they are delivered to the commodities that took place, delivered to place in the market area, then they become the pair. According to section explanation 1 Lordship, that if any delivery took place in the market area, then they become the passenger. Explanation 1 Lordship.
So use your submission therefore is in view of this explanation
1
1.3, view of this explanation, a burden is on them to show that there was no, the product was not bought and sold within the territory of state of Assam, and then they will get the refund.
They have not produced any documents that they are only they give the challenge, produced transaction challenge. They have not produced any documents before the authority that they have not bought the commodities to state of Assam for resale or had delivered not took place in our notified market area. And Lordship, for a moment, look the rule 21(2), Lordship. Rule 21(2) is 32. It is also levy and collection of cess on the sale and purchase of the agricultural produce, Lordship. 21(2), Lordship, the responsibility of paying the cess prescribed under section 21 of the Act shall be of the buyer, and such cess shall be leviable as soon as the agricultural produce is bought or sold by a licensee. Lordship, they are a licensee, Lordship, the petitioner, sir.
And licensee has been defined.
Lordship.
License. So your question, therefore, submission is, whatever may be, after the GST had come in, by those two notifications, it has been exempted.
That's it. But
By
normal
those two notification, it has been exempted.
segregate was a withdrawn loss.
Huh?
Our earlier segregate were withdrawn loss.
That's a different thing. I'm not on that. But those were exempted. Now, once they are exempted, means they were there.
That lawsuit, their delivery took place in the market, but in the notification lawsuit issued by the government of Assam, the Agriculture Department submitted that, stated that it is on 31st July 2017, when it stated that with reference to the government notification issued by Finance Department, you are directed to withdraw the segregates under establishment of Assam State Agriculture Market Board with effect from the midnight of 31st July 2017. However, formal relation of sales under Section 21 of Assam Agriculture Produce Market in 1972 on specified agricultural commodities from market will continue.
No, that's okay. Why do somebody exempt?
That's it. The council,
It has to come within it. Can the GST people exempt sale in narcotic drugs? No. It can't be, because this is, as per law, it is bound, it's banned. So it will be exempted provided it is within it. Isn't it? Now, if it is within it and it has been exempted, does it mean it is not subsumed?
the second of the interest, it is not interest. Says that it is interest.
No. The central government is inter. The Assam is intra.
Yeah.
Within the state also, if there is a state. Because their power under the Assam GST Act is within the state.
Yep.
And if it is outside, it is inter. There's no quarrel on that. But when do you exempt?
There is a notification lawsuit when
And the notification they have exempted. Meaning
But
thereby it
can
was
I also-
subsumed, therefore they are exempting it.
their delivery took place in the market area lawsuit. But they have not produced any documents that they have not been the commodities.
The council, you are not understanding that. I'm not on those. I'm on a very simple point. You say there are two notifications. One is of central government notification of 2017, followed by another notification of the state government. Once it is a central government and the state government's notification to the effect, which is already there, when do you exempt something?
Only we take the,
Unless it is brought within it.
we collect sales on the specific commodity, which are in the act lawsuit.
Understood? But if it is exempted, wouldn't
Not
it
men-
imply
has
that it is
not specifically
subsumed?
mentioned that which producer exempted lawsuit.
Huh?
In the notification, they have not specified that which commodities are exempted.
Understood. Therefore, they are exempting it. Exempting means they are saying nil. Exempting it from payment of central GST, exempting it from payment of Assam GST. Now, once they are exempting it, and you see on the right-hand side on column number 4 and 5 of those notifications, column number 3 is the description,
Description.
column number 4 is the amount of
Amount.
tax, nil.
Okay.
It has been mentioned. That has been exempted. Now, can you exempt something which is not there within your purview?
So here on only the section 20 on expression 3 lawsuit that their delivery took place in that area. So we collect sales. But they have not produced any documents that their delivery took place in the market
No,
area.
this would be on the basis that aspect we will look into it. First, you have to satisfy me on as to whether this tax have been subsumed or not. If it is not subsumed, where is the question of exempting?
Yes, sir.
You
What is
will
my-
obviously say yes.
This is my, in fact, I have Lordship annexed this notification to prove this point only. This
Oh.
notification was earlier annexed by me in the writ petition itself. Now they are producing it with they are taking it in another way. We have annexed this with the writ petition with the same content.
What is this? The exclusive power to make laws with respect to goods and service tax where the supply of goods or takes place. The commerce. What you are referring to? 101? Or just bringing, showing it to me?
In fact, in the paragraph 14, I have Lordship, in the page 14, Lordship, I have already referred. These are there already in the Lordship. The 101st Constitution Amendment 6 to amend the Constitution inter alia as follows. Lordship, I'm just referring to page 14 of my writ petition. I'm reading it and thereafter, Lordship, will show in this. Page 14 says the 101st Constitutional Amendment 6 to amend the Constitution inter alia as follows. Subsuming of various central indirect taxes and levies such as central excise duty, additional excise duty under so and so, customs duty, Lordship, we are commonly known as contravailing duty, special additional duty of customs, and central surcharges and cesses so far as they relate to supply of goods and services. Thereafter, B, Lordship, subsuming of state VAT, sales tax, entertainment tax other than tax levied so and so, so and so. Finally, and state cesses surcharges in so far as related to supply of goods and services. That was provided in the 101st Amendment, Lordship. I'll B, Lordship. We are concerned with B because we are not, it's not the central, this is a state test. So it was relating to supply of goods and services. So
Where can we get hold of Mr. B. Gogoi? Can anybody call him? He's the finance and taxation, huh?
Lordship, finance.
Or Mr. B. Chaudhary. We'll inquire with him. Because he is the person who can tell that they are the person who have also issued that document. Or Mr. Kyle, who is there for the central.
Lordship, Mr. B. Gogoi will be the because state GST,
Yes,
state GST only Mr. B. Gogoi is represented.
Because no, see, these are the interpretation, those two things. When do you exempt? Because my basic question is to exempt when it is subsumed. You don't exempt otherwise. And once it is subsumed, then your power goes. Then only, but if it is not subsumed, then only we can come to 21. Wait, after some time I'll take it up. I'll fix it on some other day on which date I will hear. Wait, let him come. Mr. Bigo. Take it up, sir. Or Mr. Kyle, whoever.
We have informed Mr. B. Gogoi is coming.
But there will be some judgments on this. The precedents will be available on this aspect as regards the, because this is not only a case of only agriculture. There will be interpretation to particularly the central notification. My question is very simple. Can you exempt something which is not? All them will find it. Next one. Wait, don't go.
Yes, sir.
$27.
I seek permission of this court to appear in this. I'm not in the. I'm appearing on behalf of I seek your lordship.
Matter is pertaining to what?
Minimum pay scale lordship, the petitioner, she was appointed.
Oh, this one. Where is he? I say, yeah.
Lordship, he is on legs in court number.
That day they mentioned this matter for that. And where's the finance? Finance is the person who is required again here.
Can I pay the matter may kindly be taken up after?
Take up after some time. Because this issue will pick up.
28.
Mr. Bora, you were there yesterday, na? You remember there's this opist matter affixed on some day.
Yesterday, I was not there.
You were not there, na? Last.
Day before yesterday,
No, the matter was yesterday. It was a matter pertaining to the copyist in Foreigners Tribunal. Who was appearing? Foreigners Tribunal person was appearing. Ali Etu matter. Ali Etu.
the affidavit,
Huh?
the standing counsel.
Mr. B. Gogoi was there. And somebody from the G. Sharma. Standing counsel Foreigners Tribunal, he was there. For home and personal. Yeah, it was next to the
28.
Hey, madam, I told you got your chance.
Please, Lordship, the petitioner was appointed on 28/10/1998 as per recommendation of District Level Selection Committee, Lordship. Kindly see page annexure 1, page number.
Yes, then
Page number 22,
you were terminated.
Lordship.
Yes, what is your case?
Petitioner was terminated abruptly, Lordship, kindly 21/5/2012. Lordship, kindly sees a termination letter, Lordship.
Yes,
32, Lordship.
then you challenged it.
Termination order was set as Lordship. Lordship, kindly see page number 46, para 15, Lordship.
Vera,
15, Lordship.
madam, are you ready with your matter or not?
Lordship.
Yes, tell me.
From the apartment, the counter affidavit filed by the district DRC Assam, it is clear that so-called notice issued earlier 18/5/10 was cancelled, Lordship. Lordship, next page, kindly see. Therefore, it is apparent that the affected person did not have any opportunity to defend their cause, and therefore the termination was not through legally permitted process. Next page, Lordship. After considering the replies of the noticee, speaking order passed, the earlier termination order 21/5/2012 issued by the Inspector of School, Nalbari, will be abided by final decision in the de novo proceeding. Thereafter, the same issue, Lordship, Fakhruddin Ali Ahmed and Saifur Rahman, Lordship, Arrears is given, Lordship. There is a division bench, Lordship, judgment.
Yes, Mr. Khatuniya.
I think
Lordship,
our
there is a division
response
bench
is
as
required,
well.
Madam, here. Our response is required, Madam.
Lordship, I have another prayer, Lordship. Petitioner has not paid 2 periods, termination period and after reinstatement for 3 months, Lordship. Kindly, I have many loss, Lordship. Kindly compensate the
Madam, tell me one thing. If the petitioner was not paid then for that period from
Lordship, I have no fault, Lordship. I was ready.
understood, madam, let us see whether you have fault or not. From 21/5/2012 to 17/1/2014 is the period where you are entitled to area salary.
Lordship.
Then you are entitled for area salary from 18/1/2015 to 1/4/2015, isn't it?
Lordship.
Why have you filed the writ petition in 2020 or 21? 22, 7 years thereafter.
Lordship, I have earlier occasion, I have
Isn't that
come
not your
this
fault?
honorable court for two
There are so many judgments of the division bench also to that effect,
3 times.
that a
Lordship.
period of area salary you can't claim more than 3 years.
I approached the respondent authority, Lordship. I have
Approaching the
application,
respondent
Lordship.
authority,
Kindly-
does it mean that you will keep on approaching the respondent authority for 5 years?
Lordship, kindly
7
see
years?
case number 85, Lordship. I have filed representation, Lordship.
So representation is okay, but then also you have to act fast. How do you take care of the 17 minutes,
They have
all
no
this
chance,
period?
Lordship.
One
They
is
have
of, one is for a period of 8 years, the other is for the period of 7 years. How do you take care of that? They will obviously require all these details for that.
Lordship, there is a division bench judgment, Lordship. Same footing, same issue, Lordship.
Very well. Let me dismiss it, go to the division bench and get an order to the effect.
Lordship, I have another prayer, Lordship. Say, WBC number 1030/2016, Lordship. No, same issue, same ground, same assistant teacher, Lordship. They have given, Lordship. Only one teacher has discriminated, Lordship. Kindly see this, Lordship.
Yes, your name. What is your name?
Deka.
Heard Mr. Deka, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatuniya appears on behalf of
Secondary education, Madam.
the Secondary Education Department. The case of the petitioner herein is that the petitioner was illegally terminated on when were you illegally terminated?
Lordship, 21/5/2012, Lordship.
On 21/5/2012.
Yes,
This court, by an order dated 1/8/2013, set aside the said termination order. It further appears from the record that by an order dated 18/1/2014, the inspector of schools, NDC Nalbari, directed the principal. Hey, this matter I have taken something similar to this. You have that, or is it a some writ petition was filed?
Lordship, earlier occasion,
You
I
filed
have-
something. Where is that order? There's another writ petition filed because I remember this letter.
I have earlier 2 times Lordship come this honorable court Lordship,
Ah.
for the area salary Lordship.
Yes, where is, what happened there?
Lordship, first order is
Not in, this matter didn't come up before this court. Has this matter come up before this court? No,
no Lordship.
some other matter came up.
Other similar.
Lordship,
Ah.
other matter.
This court by the inspector of schools NDC, Nalbari, dated 18/1/2014, directed the principal of the school in question to allow the petitioner to resume duty
Lordship,
so as to enable to complete the process of de novo proceedings till final decision was taken in compliance to the order passed by this court in WPC number 2582/2012. Thereupon, the petitioner was allowed to resume duty from 1/2/2014. And the petitioner accordingly was granted disbursed the current salaries. However, for the period during the termination, that is from 21/5/2012 to 17/1/2014, as well as also subsequently, while the petitioner was on service from 18/1/2015 to 1/4/2015, the petitioner was not given the salary. It is under such circumstances, the petitioners have represented to the authorities concerned time and again, as there was no redressal of the grievances of the petitioner has approached this court. The learned counsel appearing on behalf of the Secondary Education Department shall apprise this court on the next date as regards the entitlement of the petitioner in respect to the area salary and as to whether any steps have been taken for the purpose of releasing the said area salary to the petitioner. Release the matter again on when? 21st of June. Have it on 7th of June. Now you will get some order after all. Yes, Mr. B. Gogoi. Mr. Gogoi, what has happened is this. These matters, although you have not been made a party, but
Yes,
I
sir.
think your stand also needs to be taken note of. The contention of the petitioner herein is a challenge to the imposition of 2% tax, cess on goods which were brought and sold inside the agricultural marketing board. Now, that power is given under 20. He says that that power is given, but if there is anything, any amount which have been told, have been charged upon him at the check gate or at any other stage, but there is no purchase or sale,
Well,
By virtue of the explanation, they have to show it before the authorities and get it.
Lordship.
Here, till this point, the matter is simple. Now, thereafter, what happens in the meantime, from 1/7/2017,
Well,
the GST came in. Now, after coming of the GST, there are two notifications. One by the central government in respect to interstate,
well,
and one by the state government in respect to intrastate,
intra-
whereby they have exempted this amount which they were charging on the
Lordship.
Now, this court wants to understand what is the meaning of this as per your department, because this has a very important relevance on the point. Can you exempt something if it is not a part of it? If you have been empowered
Yes.
to tax, you can exempt. But if you are not empowered to tax, can you exempt it? Tomorrow, can the Assam government issue a notification that look here, we are not going to, we are exempting all the transactions which has happened in Bihar. You can't do that.
Lordship.
You can only exempt something which is there within your power.
Lordship.
And if you have exempted it, wouldn't it mean that you have subsumed it?
Lordship.
So that is why your assistance is.
Well,
These are two notifications. One is by the central government, one
Yes.
is, but the language is one and the same. The entry is at entry number 99, isn't it?
Lordship.
Entry number 99, clause Z. G?
Yes, Lordship.
G.
92.
So this is it.
It was there 99.
When can we get your instructions? You are not a party, but your presence is required because this
At
is
least
to be
7 days
understood.
you will-
Because the other aspect as to whether bought and sold and all these things will come later on.
Lordship.
But first they have to have the power.
Lordship.
The power will be dependent upon you.
Well,
Heard Mr. N. Haveli, the learned counsel, appearing on behalf of petitioners. Mr.
SC,
S.
SC,
Your name, why are you so?
and MJ Gogoi.
N.J. Gogoi appears on behalf of the Assam Agricultural
State Agriculture Marketing Board.
State Agricultural Market. The instant batch of writ petitions have been filed challenging the collection of cess by the Assam State Agricultural Marketing Board from the petitioners. It is the specific contention of the petitioners that the power under Section 21 of the Assam State Agricultural Marketing Board Act of 1975 or 85?
72.
72, Lordship.
72.
Assam Agricultural Produce Market Act 1970.
21 and
72
21A. Section 21 and 20.
empowers to collect tax, collect cess at the rate of 2 rupees per 100 rupees on goods which are bought and sold within the market area.
Or delivered. Delivered also.
Goods and sold within the market area. Therefore, it is the case of the petitioner that as the goods are purchased, bought and sold outside the market area, the question of imposition of cess does not arise in terms with Section 21 of the said Act of 1972. The learned counsel for the petitioner further submitted that with the coming into effect of the with the constitutional with the 101 first constitutional amendment to the Constitution of India. All taxes, including cess, have now been subsumed into a new tax in the name and style of goods and service tax. 3 enactments have been made so far as the state of Assam is concerned. One is, the first is the Central Goods and Service Tax Act 2017, the Integrated Goods and Service Tax Act 2017, and Assam Goods and Service Tax Act 2017. It is therefore the specific submission of the Learned Counsel for a petition that with the coming into effect of the GST Acts, with effect from 1/7/2017, the imposition of cess which have been made by the respondent board is not permissible and without authority. On the other hand, Mr. N.J. Gogoi, the Learned Counsel appearing on behalf of the State Marketing Board, State Agricultural Marketing, submits that by notifications dated, what are the dates of the notification?
31st July 2017.
Both are same date.
The notification dated 28 June 2017 and 29 June 2017. One is 28, other is 29.
By notification dated 28/6/2017.
This is central notification.
This is before the coming into effect of the act.
Yes,
This notification.
just before the coming of the act. Was 1/7/2017 the act came into being, because on 28 June, other was on 29 June.
How is it possible?
Worship, because the GST Act was coming, so they had already issued the notification relating to exemptions which will be available in the GST.
By notifications dated 28/6/2017 issued by the central government. 28. And the second is?
Second is 29 June 2017.
And notifications dated 29 June 2017 by the State Finance and Taxation Department, Assam State Finance. The services insofar as collection of levy by the State Agricultural Marketing Board have been exempted, as could be seen at item number, serial number 99.
Remember in the first worship,
Both are same.
54D. In the first notification, 54G.
And the other?
And that is same as 54.
Serial number 54G of both the notifications. It is therefore the contention of the Learned Counsel appearing on behalf of the respondent board that as the levy so made under section 21 of the Act of 1972 have been exempted by both the state and the central government from the purview of the Central Goods and Service Tax Act 2017 and the Assam Goods and Service Tax Act 2017 respectively. There is no embargo on the part of the respondent board to collect the taxes in terms with section 21 of the Act of 1972. The Learning Council for the petition respondent board further submitted that the explanation 3 to section 21 of the Act of 1972 makes it abundantly clear that it is the burden upon, there is a presumption when our goods are bought, which were brought within the market area, that the same are bought and sold within the market area.
Notified market area.
Notified market area. And as such, it is the burden upon the respondents of the petitioners to show to dislodge that presumption, which can only be done by the authorities. Be that as it may, a specific question therefore arises for consideration apart from others as to whether the cess so collected under the Act of 1972 was subsumed by the Assam Goods and Service Tax Act 2017. The Learned Counsel, Mr. B. Gogoi, who is present in the court, and also being the standing counsel of the Finance and Taxation Department, is therefore requested to assist the court in respect to the said aspect. This is the matter again on, yes, Mr. Gogoi.
Well, in that case, 10 days after 10.
Yeah, fix it on a Tuesday or Thursday.
30th May, Lordship.
Huh?
30th May. 30.
30th. 30, okay.
Also kindly record that there is an order from the Additional Secretary Government of Assam that the normal legislation of cess from under section 21 only continue after DST. That may be recorded.
Not necessary.
That is a parent department.
35,000. 35,000 for further consideration. Mr. Counsel, I am not writing this dictation. This is not for the purpose of I'm disposing it like I'm just recording it out there so that he can also know what is the better about.
A copy of the repetition may be served to me.
A copy of one of the repetition along with the this 1336.
Both the notifications I will give copy.
No, you give the set of 1336 entire thing.
1326.
One,
The WBC number is 1326.
whatever may be. Petitioner shall furnish a copy of the repetition along with the affidavit so filed.
And notification.
The part of the notification
I
is
have
there.
got to be part of my petition.
It is there.
Yes,
So it is not required. Affidavit repetition along with the shall furnish a copy of the pleadings in WBC number so and so to Mr. B. Gogoi by tomorrow.
Much okay.
The registration is showed the name of Mr. B. Gogoi, Standing Counsel, Finance and Taxation. You just get that. But that is the most catch. If it is there, it is okay. Otherwise, not there will.
Lordship, I pray for some more time, Your Lordship. We have not received any instruction.
Right? Don't matter. And
Lordship, at least
2 weeks, your lordship.
Barry, the Planning Council hearing for the second verification. Accommodation in the instruction terms. By
Right, right.
23,
My lord, yeah, my lord. Further 1 week time may be granted, my lord, to receive the instruction. Next week, my lord, in case.
think it will be finalized.
No, my lord. Still, my lord, there is miscommunication on my part, my lord. That's why, my lord, I could take instruction. Next week, my lord.
No, understood. Your miscommunication will be there, but then also thing is that the person has retired on.
My lord, if the proposal is in correct form, my lord, I will ask the authority to finalize, my lord. If there is no, my lord, deficiency in the document. After 10 days, my lord, I will come up with a up-to-date instruction, my lord.
Resubmitted method.
Yes,
So they resubmitted on 2/3/2002.
my lord, my lord.
2-3 lord.
If the proposal is, my lord, correct, perhaps, my lord, it settle, my lord. After 10,
The A. Hassan, the Planning Council. Accommodation. In the 21/1/2020 and 15/2000. 31st of May, 2000.
my lord,
31st of May.
my lord.
All right.
I can improve it.
item number 30,
Very good. Lordship may be pleased to the last order, the 10th of April. Direction was given and the payment. Otherwise.
It after 2 weeks,
Lordship.
get your instruction. Secretary. Mr. A. Deca, Planning Council. Barry. Planning. From May 2000, by the Harry. In the Secretary to the Government of SAM, Department of Education, seeking the sanction for an amount of 1,00,043 in respect to the year of the to account that it was only on 16/5/2000. The said communication kept up, taking into account the state communication on 16/5/2023. In the June 2000, so that the petition, or so that the Senate Council hearing on behalf of the school education, part of second government education shall applies as regard the further progress in respect to the sanctioning the amount. Get your instructions on the, because this has been quite long delay. Next time I have already put you to notice on interest.
33,
In this case, I have received instruction, my lord. Proposal has been submitted. Before the government, my lord, really. From the director. Okay, instruction.
But Mr.
Yes, sir.
E. Sharma, the learned counsel for the bill. The B. Taluk appears on behalf of the
Elementary
education. The B. Talukdar has placed before the communication issued by the Director of Education, the Secretary to the Government of Elementary Education Department, seeking their approval for an amount of rupees 3,02,400 in respect to payment of the area salary of the petitioner and one Salema Begum. Since the state publication was issued only on 16/5/2023, this court grants a further 2 weeks' time to the petition to the said to the government to the Secretary to the Government of Assam Elementary Education Department to apprise this court on the next date as to the status of the said proposal. So as to the status of the proposal seeking sanction of the said amount. Is the matter again of 5th of June.
My lord, in item 40 also because Alema Begum 46.
46.
46.
The same.
Same
That is
one,
the
same.
other one.
Other one, my lord, Alema Begum. And
Same
in that
instruction.
case, only difference is that I was paid half and for 1 year, 1 year is not paid.
46 to the auction.
Okay. Same instruction.
46 to ultai dibo. Naam to eto petitioner and 46 ot eto MAI Hussein hobo. Mr. B Talukdar eke order to agor order to ali difference hobo etia petitioner and Karima Bibi. Karima Khatun. Eto X ot rakha hoise. Document is enclosed as a the order beleg. That's it. The 16. Same order no order to kon bodli bo because naam to bodli jabo na.
Only one
Agor
difference here, my lord.
Agor to koju Karima agor to Karima Khatun ne asil.
Karima Khatun.
Aru etu thol
Salia Begum.
Second to Salia Begum.
Alema, my lord.
Eke.
Alema Begum, my lord. Alema Begum.
Hello.
36,
Last order 1/3/2023.
Lordship, in this case, I have received the instruction that inspector of the school was directed to submit the proposal for the pension.
This is matter pertains to what?
Further to my lord, compassionate family pension and not and family pension, my lord. Compassionate family pension, the father of the petitioner, my lord, expired, my lord, on 9/4/2017 while in service. Thereafter, my lord, paper was submitted for compassionate family pension. Compassionate family pension was granted and order was also passed on 14, my lord, 8/2019. Just before 4 days of this order, mother expired, my lord. So thereafter, the petitioner being his son and unmarried daughter, they applied for commission family pension from the date of father till to the date of mother, and normal pension from the date of mother to the date of at the age of majority.
Yeah, number two is already major.
My lord,
Number two is already major.
all of us are morality.
No. Unmarried daughter will get it.
Unmarried daughter till 21. Yes.
No, but what about the
And
number
my
two
lord,
and number three?
2 and 3, they have already got majority at 21 in 2021.
2 and 3 are major.
2 and 3 are major.
So they are not entitled to the compassion.
Now they are not.
Who is entitled to? Number one
Number 1,
is unmarried.
unmarried.
What is your instruction?
My lord, the Director of Pension has written to the Inspector of School to send the proposal in our name.
I'll often instruction whether face proposal hasn't.
Heard Mr.
P. Raman.
P. Rahman, the learned counsel appearing on behalf of the petitioner. Mr. S. Roy appears on behalf of
The Director of Pension.
Director of Pension, and Mr. N.J. Khatuni appears on behalf of the elementary secondary education department. Mr. B. Rahman, the learned counsel for the petitioner, duly submits that the petition 2 and 3 longer entitled to the compassionate family pension, taking into account that they have already attained the age of majority. However, the petitioner number 1, being an unmarried daughter, is still entitled to the compassionate family pension. Be that as it may, the learned counsel appearing on behalf of the Director of Pension, Mr. S.S. Roy, submits that the concerned inspector of schools have already been asked to submit a fresh proposal in that regard. Mr. N.J. Khatuni, the learned counsel appearing on behalf of the secondary education department, submits that he will take necessary instructions in that regard as to whether the proposal has been sent by the inspector. Is the matter again on 7th of June 2023. In the meantime, on the next day, the learned counsel appearing on behalf of the secondary education department shall apprise this court as to whether the proposal has been sent, and the counsel appearing on behalf of the Director of Pension shall also intimate this court as to whether any proposal has been received.
My lord, petitioner 2 and 3, they were entitled from the date of his father till 2021. They were entitled at that period. They were entitled. Now they are not entitled.
That money you have not got it. You have not got that money.
Yes, sir.
So that is why I'm saying now I have said it is not entitled. Now, if you have a fight between 1, 2, and 3, go to the civil court.
Timing
The
item 27.
entitlement remains because of the petitioner number 1. Get it?
Timing item 27.
Yesterday's case.
Not yesterday, it is same time yesterday's matter. The
Yes.
copies, man,
Yes, well, that is fixed on 25/5.
will have it this on 25.
Yes.
Along with that.
Along with WPC 186 of 2012.
That is matter, my lord. Here, I had also 2 cases, my lord. I have withdrawn.
Huh?
Those cases were filed, my lord, for non-payment of, my lord, their monthly salary. That has been paid.
Not your matters. There is another matter where there was the issue as regards the copies of the foreigners tribunal. Now I have asked them the question as regards whether there is any sanction post available or not. That is one aspect of it. The second aspect of the matter is as to whether they are entitled to the minimum of the scale of pay. Now you are claiming minimum of the scale of pay. Now the objection which have been raised by him is Upendas. Now this Upendas concept, I have said that Upendas is only in respect to Jagjit Singh. Now you have to understand Upendas on the basis of a 10-year period. Not on the basis of that from 2017 to 10. Because this tomorrow, another 10 years down the line, are you still going to say about Upendas? if a person's mature, then wouldn't that order by the division bench become? Because this is not a case by which the court has given on any other basis. The court gave that as they are working for the 10 years, you should not do, unless it was on the basis of a concession. Now, if they say it to be a concession, then we can revert back to Zaglu. If they say it is not a concession, then in view of the direction, we'll take it as 10 years. So this way or that way, it has a two-sword edge for the department. So that is why I'm taking up that matter on 25/5. That day I will take up this matter so that we can dispose it. 25 is Thursday. It's the matter heard.
Along with
Mr.
my lord, 186 of 2012.
Heard Mr. A.I. Saikar, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi appears on behalf of the finance department. Who appears for home and political? You.
1 and 2, Lordship.
Ms. A. Talukdar appears on behalf of the home and political department. Is the matter on 25/5 along with WPC number 186 of 2012. 12.
186 of 2012. 186 of 2012.
37.
May I please, Your Lordship? Lordship, matter pertains to my lord's petitioner has sought for a one advance increment by acquiring BH degree. My lord. It
Oh,
is
this
a-
matter is covered, na?
Similar.
It will to dispose of court degree. Yeah, BTC? No BTC.
No, no, my lord.
এখনৰ মতে চাই দিব নামটো তেখেতৰ লৈ your name
My lord, S. Hazarika.
S Hazarika D Musairi appears on behalf of the respondent numbers
Number 1 and 2, Your Lord. 1, 2, and 4.
and Mr. R Borpujari appears for respondent number 3. Kori baki gita the case of the petitioner is that how many petitioners?
My lord, 1.
Teacher are therefore entitled on advance in that respondent khali eta ase. They have to file it only before that particular respondent number 4. So order 3 and 4 will pass. Inspector of school.
Deeply obliged.
39.
Yes, madam.
In this case, my lord, after notice, first time this matter is listed, so I pay some more time.
On payment of salary, Lordship. Since 2005, my service is regularized.
1 week or 2 weeks. After
Oh, Mr. Talukdar, you must have forgotten. This court doesn't go into that aspect. That it has come for the first time. Give me another chance or 2 chances to that effect. It has come for the second time. You are supposed to get your instructions. That is why I gave you 1 month time. Then.
Lordship may fix it on Friday next, my lord. Then I will.
Fantastic.
Lordship.
That is better. Heard Ms. S. Sangupta, the learned counsel for the petitioner, Mr. B. Talukdar appears on behalf of the respondent number 1, 2, 4, 5, and 6. Mr. R. Borpujari appears for the respondent number 3. This court by the order dated 11/4/2023 had asked the learned counsel appearing on behalf of the, which department is that?
Elementary education.
Elementary Education Department as to why the petitioner have not been paid the salary upon being regularized by the order dated 28/2005. Pusta. No instructions have come. Be that as it may, taking into account that the petitioner have not been paid any salary for more than 17 years, 18 years, almost 17 years. Almost 8. that the matter will be listed again 9th of June, on which date, if no instructions are received from the elementary education department, this post shall be constrained to call the officer, hearing official for which the litigation has arisen.
40,
Last occasion, they were directed to obtain instruction.
Yes, Lord.
As regard non-payment of even encashment. PIF. Retired government.
You have not got the leave encashment in GIS.
Lordship, we have received that instruction that is dated 29th of April 2023, whereby the Commissioner Food and Civil Supply Consumer Affairs Lordship has intimated that the senior accounts officer, Office of the Principal Accountant General, ANE Assam, has authorized to the sub-divisional officer Nazira to draw and disburse arrear pay and allowances with effect from 23/6/2009 to 28/2/2017, the same period. From the Treasury Officer Nazira in respect of Sri Shakil Ahmed, retired Assistant Director so-and-so, authorization letter enclosed. It is to be mentioned here that the Shakil Ahmed had filed a writ petition. Accordingly, Lordship, the direction was given to the sub-divisional officer C. Nazira.
And Mr. Sharma, I'm
Lordship.
not asking that. There's no quarrel that that amount has not been paid.
Lordship.
Question is whether you have paid the leave encashment in the GIS amount.
No, Lordship, that arrear
is-
pay and allowances, whether it includes that.
No, that has been already received. That is why on 10/4/2023, she has already stated that.
No, Lordship, that was not received.
When was it received?
That's because this letter is dated 29th of April 2000.
29th April to whom?
This letter is written to the SDO Civil Nazira
By?
by the Commissioner
To pay the?
to pay the arrear pay and allowances with effect from 23/6/2009 to 28/2/2017.
We are not on that, on the area pay. We are on the question of leave encashment in the GIS amount. He has already retired.
Lordship. Arrear pay and allowances. Lordship, in that case, Lordship, that
Because the counsel for the petitioner has on the last occasion only apprised that she has got the other things except leave encashment in GIS amount. And that is the specific question query which was made on
arrear
the
to
last
patient.
occasion.
Arrear to patient.
Leave encashment. It's because Lordship, they have filed one affidavit stating that no leave encashment is due to me. Lordship, in affidavit reply, we have annexed one document here, Lordship.
So
when
they
this is
say
stated-
that there is no leave encashment due to you.
That they said, but prior to Lordship, we have in a reply submitted one document, your Lordship, dated 13 January 2023, where it has been stated, your Lordship, 254 days is entitled. I am entitled to 254 days of leave.
Where?
In our affidavit in reply, your Lordship,
Copy of the?
copy of its instruction from the senior accounts officer to the undersecretary.
Where is that?
It's
Annexure?
page 58, Lordship. It's a
In inviting reference to, I am to submit that as per the available records personnel in respect of Sir retired director, that a request from the government for forwarding the unutilized leave invoice does not appear to have been received. However, as the case is sub judice, it is informed that as per available, the personal file of Iman was at his credit, earned leave for so and so on the date of his superannuation. Then,
Lordship.
so he had this superannuation leave encashment of 254 days. And what
Yes,
about the
Lordship.
GIS?
Lordship, then Lordship, I have to specific instruction regarding it. We have to obtain. Lordship.
Because what instruction you have given, kindly
Okay.
see, it is already taken on record as annex with X. With reference to the cited, I have the honor to inform you that the petitioner was serving as a superintendent of food and civil supplies from Borpeta from March 2009 to February 2011.
Lordship, Lordship.
He had a gross salary of a year. Further, it is to mention that the earned leave account of the petitioner. So no records of earned leave account is available in the office. This is X. And then this another document is so and so total net salary, so and so net amount of bill. So we are only concerned with these two.
Lordship.
And what about the
leave
GIS?
encashment and
What did they
GIS.
say?
Leave encashment and GIS, Lordship.
Yes,
Lordship.
get your instructions on that.
Lordship, Lordship.
Miss B. Bhuya, the learned senior counsel, assisted by. And hear you.
M. Chakra.
And so, appearing on behalf of the petitioner, Mr. H. Sharma appears on behalf of the Food and Civil Supplies and Consumer Affairs Department. This court by the order dated 10/4/2023 has specifically asked the Food and Civil Supplies and the Consumer Affairs Department to obtain instructions as regards the entitlement of the petitioner as regards the entitlement of the petitioner pertaining to leave encashment and the GIS amount. The learned counsel appearing on behalf of the petitioner has drawn the attention of the communication issued by the senior accounts officer of the Office of the Principal Accountant General AE dated 18th of January 2000. What is this?
23.
Huh?
23.
2023.
Yes.
Wherein it has been mentioned that the petitioner had to his credit leave for 254 days as on the date of his superannuation on 28/2/2017. In that view of the matter, the counsel appearing representing the Food and Civil Supplies and Consumer Affairs Department is directed to obtain the necessary instruction in terms with the order dated 10/4/2023. Is the matter again on 9th of June.
That's leave encashment and GIS, these two, Lordship. Lordship.
As well as what I have referred out there, he had 254 days.
Lordship.
Get a copy of this order or email it to those people concerned. So that they
41.
can get it.
41.
I will be allowed 1 week time for in the status of it.
Yes, what is the status of the family pension, madam?
1 week time may be given, my lord. I have not received a status of.
None appears on behalf of the petitioner on call. Ms. D.S. Naik, the learned counsel, appearing on behalf of the Irrigation Department, seeks for an accommodation for a week to obtain the instructions in terms with the order dated 31/3/2023. This is the matter again on 12th of June 2023, on which date the learned counsel appearing on behalf of the Irrigation Department shall obtain the necessary instructions as sought for by the order dated 31/3/2020. R. Kanan appears on behalf of the petition and appears to tell you.
42.
Yes.
The matter relates to pay protection. Lordship is.
Yes, what do you stand?
Lordship, we need further time. We have not yet received instructions.
You're not asking? You're not asking for the time you were sitting down?
No, Your Lordship.
This is a
finance-
matter for instructions only.
No, finance actually, finance is the
So
main
finance is going to do that.
fixation of pay. Your Lordship.
His pay which he has received while serving in the army school, Tezpur, was the pay scale of so and so, and his grade pay was a basic pay of joining the post of upper division assistant cum counselor in the firm. Yes, no affidavit.
I beg apology, my lord. I may have to reconstruct the file, my lord. I'll be seeking a copy of the petition from my learned colleague. Lordship will kindly grant me some time.
Mr.
M. So.
M. Chaudhary, the learned counsel appears on behalf of the petitioner. Mr. D. Bora appears on behalf of the respondent number 1 and 2. Mr. R. Bopujari appears on behalf of the respondent number 3. The counsel for the respondent submits that they would be filing an affidavit in the matter. Taking into account above that the matter be again listed on 26th of June 2023. The affidavit be filed by of June 2020.
47.
Here, Malat, I'm praying for some more time, Malat.
Bye.
So, Malat, the Director of Secondary Elementary Education requested the District Elementary Education Officer to submit the proposal, Malat. Till date, Malat, he has not submit, Malat.
So you have no control over your director, district elementary officer.
Normally we have, Malat, but in this case, Malat, he is taking some extra time, Malat.
Why?
I'm not sure, Malat. That is why I'm praying for something. In fact, Malat, I have a communication.
Issued notice on such and such date. Here is a case that after it is further seen that the director on the basis of had reinstated the husband of the petitioner to his original post with immediate effect pending journal. But it appears that the husband of the in the meantime had expired on the money. So it appears that so has issued a non-dual certificate of an amount of so in favor of the husband and has also mentioned that said amount could not be disbursed on account of non-availability of fund. This was given on 8/2/2023.
Yes,
The matter has come from time to time. On
3rd May also, the director
this
returned to
aspect of the
the
matter was duly mentioned in the order. However, in the instruction dated certain other aspects of the matter have been mentioned about pendency of the criminal proceeding. Under such circumstances, this court again directs the so and so as to why the amount has not been paid to the widow, which otherwise is due to the husband of the petitioner who expired on so and so. Then again, the matter has come up on 3/4/2009. On the next date, so and so shall obtain instruction in terms with the order dated so and so. Then
well, I have received a communication
we'll
from,
call that person concerned the director of elementary education.
in fact,
Then only it will remand it. Then if he has no control, let us see. Hear it from his or her own mouth that she does not have control over her officer. He or she has no control over the officers. It will look better, na? Now we are always in live streaming. They'll let the also public see the state of affairs in the elementary.
yes, elementary.
Elementary education department, the state of affairs, where the higher officials have no control over the junior officials.
I want to make a try, my lord.
Don't you do all these things that there is a scope of, what do you call? On the ground of insubordination
Yes,
or
yes, my lord.
disciplinary
Yes, my
action?
lord.
Why haven't you taken that? Then
Give me last one opportunity.
we hear the people, our government is moving on some bullet speed.
Yes.
Is this a bullet speed? It's not even a bullock speed. Then tell me. Because it takes after 5 days. Every time the matter has to come, this court has to pass an order. This is also a problem not only to them, also as regards the registry also, this is the problem. Matter getting listed every time on the getting instructions, nothing has happened. More particularly when the block elementary education department have categorically mentioned
Lord,
that yes, he's entitled to.
Yes, in
The
fact,
person died so long back in 2020, the wife is trying and fighting tooth and nail to get an order, to get this money, she's not getting it. How much sufferings are these
I understand,
officials going to give?
I understand, my lord.
Heard, Mr.
Arya.
Ari Ahmed, the learned counsel for the petitioner. Mr. N.J. Khatani appears on behalf of the Elementary Education Department. Mr. Khatani, the learned counsel, submits that the Director of Elementary Education Department have already taken steps with the District Elementary Education Department. However, the District Elementary Education Department officer have not done the needful, and as such, the instructions are awaited. It surprises this court in the manner in which the elementary education department is being functioning in as much as this court, in as much as the block elementary education officer Bilasibara had already issued a non-royal certificate of an amount of rupees 2,62,242 in favor of the husband of the petitioner. The husband of the petitioner expired on 9/9/2020. This court, by the orders dated 8/2/2023, 1/3/2023, 10/3/2023, 3/4/2023, and 12/5/2023 have sought for the instructions as regards the entitlement of the petitioner to the said amount. However, in spite of so many opportunities being granted, that the elementary education department seems to be reluctant in providing the information. This court grants a final chance, when 1 week,
Yes, my lord.
final chance to obtain the instructions by 5th of June 2023. If it is, this court further makes it clear that if no instructions are obtained in the meantime, on the next date, this court would have no other option but to call for the presence of the Director of Elementary Education on such date as may be fixed by this court.
Obliged, Lordship.
48,
In this case, my lord, I have received instruction, my lord, pension proposal is submitted for the director of pension by the elementary.
You submitted yesterday.
Letter is yesterday, submitted on
11/5.
my lord. Letter to senior standing council.
So you have submitted.
My lord.
You have not received. Hello,
Lordship,
you have not received it.
because I have the instruction till 3rd of May, Lordship.
3rd of May.
Yes,
You have
sir.
sent on 11th of May. You have not received. Heard Mr. K. Mujumdar, the learned counsel appearing on behalf of the petitioner. Mr. B. Talikda appears on behalf of the Elementary Education Department. Mr. S. R. Borwa appears for the Director of Pension. The learned counsel appearing on behalf of the Elementary Education Department submits that the proposal have been again submitted by the Deputy Inspector of Schools, Nagaon, on 11/5/2023 to the Director of Pension. Into account, it was taken the same in 12th of June 2023, on which date the learned counsel appearing on behalf of the Director of Pension shall apprise as regards the status of the pension proposal insofar as the petitioner. The documents so placed on record by the learned counsels appearing on behalf of the Director of Pension as well as the Elementary Education Department are kept on record and marked with the letter Y and Z respectively.
51,
Yes, madam. Is this the matter where you wanted to, I asked you to withdraw?
Yes, Lordship.
Okay, now what have you got?
My lord, I have received Paraby's comment, sort of instruction, my lord. I have sent it for.
And the next date
Vetting.
as to why the husband of the petitioner was not paid the area pension for the period from 1/6/2011 to 3/12/2018. Now she is getting the family pension.
Yes, Lordship.
Regarding area, my lord, I'm just placing this before your lordship. I want to put this on affidavit, but still, my lord.
Oh, first and foremost, tell me, you want to file an affidavit, is okay, fine. But only tell me whether he is entitled to.
My lord, we have moved to the department has, my lord, written to the accountant general in 19/12/2022 to consider her thing.
No. She is entitled to the family pension in view of section Rule 140.
Yes, my lord.
41. Meaning thereby, Once he is entitled to family pension, it is admitted fact that the husband will also be entitled to pension. And if he is entitled to the pension, there is no quarrel with the question of entitlement. It is a question of when are you going to pay? Why do we need your affidavit then?
My lord, we have already written to the accountant general.
I'm not
We have
concerned
forwarded
how
the-
you do it. That is your lookout. You write it to the accountant general, you write it to the director pension, very well, write to everybody.
My lord,
But only question is that whether the petitioner's husband was entitled to. And if he was entitled to, obviously that amount is to be paid. Unless, of course, you are saying that the petitioner is not entitled to the family pension. Is it your case?
so we said, my lord, that that was not sanctioned by the accountant general.
Which one?
This lifetime area pension, my lord, from 2011 to 2018.
I'm not concerned with that. Petitioner is getting the family pension.
My lord,
If the petitioner is getting the family pension, a family pension, this is not on a compassionate family pension.
no, my lord,
It is the regular family pension under the rules of 1969.
my lord.
Meaning
He
thereby,
retired, then he died.
that person had the qualifying service.
21 years.
Meaning
if you
thereby,
don't-
that person had minimum 1 year of regular service, which is required. So all these are there. So if that is so, why not the area salary, area pension?
My lord can dispose of the matter only quoting this. That is what my lord can dispose of this matter today also. That is what I just want to place the instruction once my lord looks into it, my lord.
But you said that you wanted to file an affidavit.
My lord, that was my into my lord. To be the safer side, when I want to put everything on record.
What is there to put on record when you are already given, unless you are denying that the petitioner is not entitled to family pension?
My lord will just 3 I have flagged this 1A and 2. These 2 flags, my lord. That will
It
clarify my
refers that
stand.
the honor to forward with the application in original submitted by Spencer for considering her application LTA pension. What is this? Lifetime? What is LTA?
Lifetime area pension, I think my lord, they have written it.
Oh, a lifetime area pension. The thumb impression of so and so is enclosed. So this is you have forwarded.
My lord will just check this 1A, that flag, my lord. 1A. That is the internal communication of the department, my lord.
I have the honor to inform that so and so MR labor of this was retired on so and expired on family pension limited to property time and the pension sanction to the so and so lifetime. Yes, accountant general. The accountant general normally is available, for all matters, but here when the matter comes out, have you made him a party?
I
Oh,
will
yes,
just check
he's
out,
there.
my lord.
Eh, Lala. He's there.
Yes, he's
Where's the accountant general?
7 is there.
Madam, just wait for some time. We'll get hold of this accountant general. Pass the order.
Because if you go by this instruction, my lord, then he's under.
We will pass an order. Wait. You are here.
54.
May it please your lordship. Lordship, I have suspended for the last 148 days. On last occasion, they 6 times to file affidavit. No affidavit has been filed yet.
We have received instruction and there is no department procedure has been initiated. We have
Oh, when did you suspend him?
Suspended on 21/12/2022, Lord.
Have you served the memorandum of charge? No.
No, your lord.
Initiated from this end and the matter is under investigation. No review order of suspension made from the higher authority. Regarding filing of charge is dependent on. These people, they don't know what is this. What do you mean by memorandum of charge oblique charge sheet? It means this is, have they given anything to the effect? But Mr. P. Bodlow, the learned counsel appearing on behalf of the petitioner. Madam, your name?
S. Kemprai, Lord.
S.
Kemprai.
Employee appearing on behalf of
Karbi Anglong Autonomous Company.
respondent number 1.
Respondent
Respondent number 2, 3, and 4.
Yes, Lordship.
Who appears for respondent number 1? Forest.
Forest.
None appears on behalf of the forest department on call. Okay. The case of the petitioner herein is that the petitioner was put under suspension by an order dated 21/12/2022 in pursuance to the KAAC Department of Environment and Forest letter dated 19/12/2022. You are,
For the forest department.
your name?
I'm Kalita, your lordship.
And so appears for the forest. Respond number 1. Councillor. The writ petition has been filed on the basis that the respondent numbers 2, 3, and 4 2, 3, 4 and respondent numbers. Who has done this? The respondent number 4, who has passed the suspension order?
Respondent 3, lordship.
Where is the suspension order?
Annexure E page 26.
Huh?
Page 26.
That the respondent number 3, the case of the petitioner, that the respondent number 3, who is also the disciplinary authority of the petitioner, till date had not issued the memorandum of charge oblique the charge sheet under the provisions of the Assam Service. You come under the Assam Service Discipline and Appeal Rules 1964. The learned counsel appearing on behalf of the petitioner referring to the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary versus Union of India reported in 2015, 7 SCC 291. Were you arrested?
Not lordship.
No. You are not arrested.
No, lordship.
Referring to the judgment of the Supreme Court in case of Ajoy Kumar Chaudhary versus Union of India reported in 2015, 7 SCC page 291. And further relying on paragraph number 21 of the said judgment had submitted that the currency of a suspension order should not exceed more than 3 months if the memorandum of charge oblique the charge sheet has not been served upon the delinquent employee. This court, while issuing notice on 4/4/2023, had directed the respondent number 2, 3, and 4, the respondents, to apprise this court as to whether the memorandum of charge oblique the charge sheet has been served upon the petitioner, as well as also to obtain instruction as to whether the law laid down by the Supreme Court in the case of Ajoy Kumar Chaudhary Supra has been followed. Today, Ms. SMS, the learned counsel appearing on behalf of the respondent number 2, 3, 4, and 5 have submitted that till date, no departmental proceedings have been initiated, as well as no memorandum of charge oblique the charge sheet has also been submitted, served upon the petitioner. Taking into account that the petitioner was suspended as on 21/12/2022. And more than 5 months
Lordship.
is over.
More than 4 months over, 148 days to 148 days to
More than 148 days is over, but no memorandum of charge oblique the charge sheet has been served upon the petitioner. This court holds that the further continuation of the suspension order would be contrary to the law laid down by the Supreme Court in the case of Ajoy Kumar Chaudhary Supra. Accordingly, this court therefore directs the respondent number 3, upon production of a certified copy of the instant order, to forthwith reinstate the petitioner. This court further taking into account the observations of the Supreme Court in paragraph number 21 of the said judgment in Ajay Kumar Chaudhary further gives the liberty to the liberty to the respondent number 3 to transfer the petitioner to some other office so that
Already transferred, Lord.
transferred where?
Lordship, after the suspension, Lordship, they have transferred to another office.
No, it transferred. I'm giving only the liberty
Lordship.
to transfer the petitioner to some other office of its under the respondent number 2. Under the respondent number office under the Karbi Anglong Autonomous Council before. So that good goal. We have Ajay Kumar Chaudhary.
Lordship.
Be at liberty to transfer the petitioner to any of its offices so that to sever any local or personal contact that the petitioner may have and which he may misuse for obstructing the investigation against him. The respondent number 3 may also is further given the liberty to prohibit the petitioner from contacting any person or handling records and documents till the state of his preparing his defense. This court further taking into account the judgment of the division bench of this court in the case of State of Assam versus Ojit Sonua, reported in so and so 2023, that's the date. Further observes that upon serving the memorandum of charge oblique the charge sheet for reasons to be recorded, the authorities may, in exercise of the powers under Rule 6.1, be at liberty to exercise the powers under Rule 6.1 of the rules of 19. The instructions were submitted by Ms. S.M. So-and-so, the learned counsel for the respondent number 2, 3, 4, and 5, kept on record and marked with the letter X.
Obligation.
Timing item 51.
Yes, madam. In this case, why you have not given the sanction for the area salary?
Lordship, some time may be given, the instructions, 1 week time.
You see, madam, let me tell you one thing. The husband of the petitioner retired on a particular date. After that, he was entitled to his pension. He died thereafter. Pursuant to that, you as well as the department have got together and said that the petitioner is entitled to the family pension. You know the consequences of giving the family pension, meaning thereby the services was okay. The petitioner, the husband was entitled to the pension. then only the family pension will come. Now that period, when the husband of the petitioner did not get the family pension, the authorities concerned say that he is entitled to, but you have not granted the sanction.
Lordship, we have sent the to the department.
Then
It is awaited, Lordship,
to whom?
from the department, accountant general.
Oh, get your instructions on this. Heard Miss M. Nirolda, the learned counsel appearing on behalf of the petitioner, Mr. Rahul Dar appears on behalf of the respondent numbers 1, 2, 3, and 4 and 5. Mr. S.R. Borwa appears on behalf of the respondent number 6, and Miss
A. Lala.
A. Lala appears on behalf of the respondent number 7. The instant writ petition has been filed by the petitioner, claiming the area pension which her husband was entitled to for the period from 1/6/2011 to 3/12/2018. It is relevant to take note of that the petitioner is at present receiving the family pension. Mr. Ardhor, the learned counsel appearing on behalf of the respondent number 1, 2, 3, and 4 has also submitted that it is on account of the accountant general AE not sanctioning the area pension of the husband of the petitioner. The husband of the petitioner during his lifetime, as well as the petitioner now, have been deprived of the area pension. Taking into account the same, the learned counsel appearing on behalf of the accountant general AE is directed to obtain necessary instruction as to why the petitioner would not be entitled to the family pension, to the area pension, to which her husband would have been otherwise entitled to if he was alive for the period from 1/6/2011 to 3/12/2018. Please the matter again on
Next.
Lordship, a week time.
7th of June. 7th of June. But 7th of June means this is not 1 week. You are asking for 1 week. I have given you more than that. I hope something happens. You want to keep it?
My lord has quoted that communication to the AG, my lord. Order, my lord. Just please.
No, you'll get it. Not
We'll help them.
necessary. They know all this. At this stage, this code, this code further finds it relevant to refer to a communication bearing number CON/197/2020/3853 dated 19/12/2022 issued by the Executive Engineer PWRD issued to the Accountant General AE regarding the long lifetime area pension with effect from 1/6/2011 to 3/12/2018. Should I keep it? Better, no?
Better, my lord.
The documents so placed by Mr. Ardhor, the learned counsel during the course of hearing is kept on record and marked with the letter X.
My lord, I did not file this affidavit anymore. All the annexures are there.
Eh?
All the annexures are there. If I have to file.
No, not necessary.
My lord.
Because your problem is not there. They have to do it.
$55.
This matter, my lord, BTC is main party, my lord, BTC, Irrigation Department, BTC.
Fourth round litigation.
Appears. These departments have no business.
My lord, BTC, my lord. Irrigation.
BTC will have to traverse the my lord allegations in the writ petition.
Heard Mr. A. Hussain, the learned counsel for the petitioner. None appears on behalf of the BTC.
4 and 5.
Is required to
That impugn order, my lord, was filed by the Commissioner and Secretary of Elementary Education Department. Lordship may be pleased to come to page 152 of the writ petition. That is the impugn order which is put to challenge here. There was an earlier round of litigation, and that 152, Lordship will kindly see the last but one paragraph.
as report the BTC authority has not taken policy for granting stipendiary grade of to those ventures. Then it has not taken any policy on being indicated previously by the 10. Yes.
Status notice, madam. Kindly allow one witness.
You do one thing. I give you more than that. File your affidavit without fail. But Mr. A. Hussain, the learned counsel appearing on behalf of the Mr.
R.K.
E. Musari.
R.K. Musa.
R.K. Musari appears on behalf of the respondent number 4 and 5. On a perusal of the order dated 29/5/2020, issued by the Government of Assam Elementary Education Department, issued by the Commissioner and Secretary to the Government of Assam Elementary Education Department. It is clear that on account of the BTC authority having not taken any policy decision for granting stipendiary grade granting aid to those venture schools, the claim of the petitioner for granting aid was not granted, not given. Taking into account the same, this court. Mr. R.A. Musari appearing on behalf of PTC, appearing for the respondent 4 and 5, submits that he would like to file an affidavit in the matter. In of June 2023. Respondent number 4 and 5 is directed to file the affidavit 15th of June
56.
God bless you.
My lord, in this matter, I have sought for budget for payment of the arrears salary, sir. Once that is received, sir, we have sought for budget for the period, my lord.
Huh?
We have sought for budget for payment of the salary, my lord, arrears salary.
You sought for budget
My lord.
from whom?
My lord, that is the issue, my lord. We'll take some, the instructions are a little lacking, my lord, but the instructions are clear that we have sought for budget. We do not contest. We are just waiting for the budget to be released. Sometime may be granted, my lord. I find the complete instruction.
When?
2 weeks. We'll take the instruction.
The R.P. Goswami appearing on behalf of the respondent number 1 to 5. submits that he requires a further 2 weeks accommodations to obtain the instructions in terms with the order dated 11/4/2000. Accordingly, the matter can be treated on 15th of June 2023, on which date the learned counsel appearing on behalf of the respondent number 1 to 5 shall apprise this court as to why the petitioner have not been paid. Why the petitioner have not been paid the area salary during the period of his suspension, and when such payments shall be made.
My lord, we have otherwise agreed that the payment has to be made. We have fought for budget.
Then when? Why to Gusario? Why remove? When the said amount of shall be.
57.
Lordship, here in this matter, I have received telephonic instruction, Lordship. No review, no manner.
It's an order.
No review.
No, Lordship.
Heard Mr. M.K. Chaudhary, the learned senior counsel, assisted by Mr. A.U. Ahmed. Learned counsel appearing on behalf of petitioner D. Upamanyu appears on behalf of respondent number 1 and 2. The case of the petitioner herein is that the petitioner was arrested in connection with Borpeta PS case number 1058/2022 on 30/12/2022. Pursuant thereto, that the petitioner was put under suspension by the Director of Higher Education in exercise of the powers under Rule 6.2 of the Assam Service Discipline and Appeal Rules 1964. For short, the rules of 1964. What is the order dated?
4th January
Suspension is dated 4th of
2023.
January.
Thereto, the petitioner was put under suspension by the Director of Iman excess of it on 4/1/2023. Subsequent thereto, on 9/1/2023, the petitioner was released on bail by the Judicial Magistrate First Class, Borpeta. It further appears from the records that the bail order was brought to the attention of the respondent number 2 by the communication dated 10/1/2023. However, in spite of the said, the respondent authorities have neither taken any decision in terms with the provisos to Rule 6.2, nor had submitted any memorandum of charge oblique the charge sheet upon the petitioner. It is under such circumstances that the petitioner has approached this court on the ground that the further continuation of the suspension of the petitioner would be contrary to the law laid down by the Supreme Court in the case of Ajoy Kumar Chaudhary versus Union of India and another reported in 2015 7 SCC 291. This court, by an order dated 26/4/2023, had issued notice and directed the learned counsel appearing on behalf of the respondent number 1 and 2 as to whether, and to apprise this court as to whether there has been compliance to the law declared by the Supreme Court in the case of Ajoy Kumar Chaudhary Supra. This court further fixed the matter on 12/5/2023. However, when the matter was listed on 12/5/2023, there was no instruction received by the learned counsel appearing on behalf of the Higher Education Department. Accordingly, the matter has been listed today. The learned counsel today, the learned counsel for the Higher Education Department, Mr. D. Upamanyu, submitted with all fairness that as per his instruction, there is no memorandum of charge or charge sheet issued or served upon the petitioner till date. Taking into account the same, this court, taking into account that a period of more than 90 days have elapsed from the date of the suspension, from the date the petitioner had intimated the respondent authority, the respondent number 2, is the director,
Yes.
respondent number 2, that he has been released on bail. This court is therefore of the opinion that a further continuation of the suspension order would be contrary to the law laid down by the Supreme Court in the case of Ajoy Kumar Chaudhary Supra. Accordingly, the instant petition stands disposed of with the following observations and directions. Number 1, the further continuation of the suspension of the petitioner on the basis of the order dated 4/1/2023 is contrary to the law laid down by the Supreme Court in the case of Ajoy Kumar Chaudhary and Supra. And as such, the respondent number 2 is directed to forthwith reinstate the petitioner upon a certified copy of the instant order is served upon the respondent number 2. This court further gives the liberty to the respondent number 2 to post the petitioner in some other office of the petition under the respondent department.
The principal of the college, that is not.
Huh?
College.
Then how can it be that if you are following Ajoy Chaudhary, that has to be given?
That liberty can be given, but they.
I'm not directing, I'm giving the liberty. Is that Ajoy Kumar Chaudhary
Has been annexed, Lordship, page 33.
This court further gives the liberty to the respondent authorities. More particularly, the further gives the liberty to the Director of Higher Education to transfer the petitioner to any of its offices, or colleges within under its authority, so as to sever any local or personal contact that the petitioner may have and which he may misuse for obstructing the investigation against him. The respondents are further given the liberty to prohibit the petitioner from contacting any person or handling records and documents till the stage of his preparing his defense. Further to that, in view of the law laid down by the division bench of this court, in the case of State of Assam versus Ojit Sonwal reported in so and so, this court further grants the liberty to the respondent authorities upon service of the memorandum of charge or the charge sheet upon the petitioner, and for reasons to be recorded, to exercise the power under Rule 6(1) of the Rules of 1994.
Obliged, Lord.
Number 60.
Yes, madam.
Matter is regarding payment of high salary.
You have taken dusty service.
Yes, Lord.
You have filed it. Filed an affidavit? No. Not done it.
Here it is.
4, 5, and 6 is otherwise complete, no? Yes, what is your case? that the petitioner have not been paid the area salary as well as the retirement benefits gratuity if the encashment etc. in spite of persistent requests being made by the Assam. This same matter, we have it up there, no? What is the date?
Yes, 29th, 29th, no? 29th.
We'll list it with that. Those matters I've got a bunch now. Heard Miss. So and so the learned counsel for the petitioner, Mr. Ardhor, appears on behalf of
1 and 2, my lord.
respondent number 1 and 2. Mr. Arbor Pujari appears for the respondent number 3. None appears on behalf of the respondent number 4, 5, 6, and 7.
They are the main respondent, my lord, actually. They are entry.
They are always.
Taking into account that a similar matter pertaining to a matter pertaining to the similar, taking into account that issues raised in the instant petition is also being taken up by this court in another group of petitions. Let this matter be again listed on 29/5/2023 before this 29/5/2023 along with WPC number.
I will just.
There it is. 9 of 20.
What Chandra 2016 matter? 2016. That's it. What Chandra Wari, that party mean 2016 matter. I will just give the number.
Number 29.
May I please? Sir, kindly the order dated 3/6/2022.
Oh, this is a 2011. Same matter.
Same, my lord. This Nirupoma Boro and others. There is a series, my lord.
That day I was looking into the judgment which I have referred to in case of full pension of the PWD matter. We're not there. For the matter that I have referred to, the recent judgment of justice. Got Rashna Hills.
My lord was not. My lord is not audible.
Rashna Hills.
Rashna Hills.
Have a look at that.
Yes, ma'am.
There, what has happened? A person, there was a particular selection proceeding. Pursuant to this particular selection proceedings, there was a requirement of an approval from a particular authority. From the government, I suppose. This was done by some madrasa or something to this. Selection done, everything done, then it was placed before the authority concerned. The authority, in the meantime, waited for some time and then came up and look here, we have changed the rules. As such, you submit your proposals, this selection is. Then the petitioners came up before the court, because Madhya Pradesh High Court has, and said that, see, everything has been done, or it is only the approval is to be given. Then, and it is in fact a case of a deemed approval.
Yes.
So the learned single judge in Madhya Pradesh High Court held that no, his approval was only just for the sake of it. Everything has been done, nothing else. It's such the old rules will follow. Now, no, the old rules will follow, and as such, they were directed to again consider.
Yes.
They considered it, and so nothing doing. New rules will follow. So again, another writ petition was filed. And a contempt proceedings was initiated. While initiating the contempt proceedings, the government bowed down to, out of fear of the contempt, did it. Matter was taken in appeal, division bench. Division bench didn't do anything. Matter went to the Supreme Court. Supreme Court considered two issues. Whether the approval can be taken to be a deemed approval or useless, with the selection having already been done. And the second is as to whether the new rules will apply, taking into account that the selection proceedings have already started. Although the case of Rajkumar is a case for promotion, but the principle of Rajkumar, which was there, by which Rajkumar had overruled the Rangaya.
Yes.
Rajkumar's judgment, which was there, that Rajkumar's judgment was followed in a direct recruitment. Very recent judgment. Have a look at it. So you can very much, don't you think you can apply that aspect to the matter? That unless 10-4 is notification doesn't come, they cannot happen. Because that was that case.
Here, in our case, the 2011 was struck down by this honorable court, not it was repealed by the 2017 Act, but it was struck down by this honorable court.
No. So the saving under 2024 by section
24.
Can it be saved, a thing which has not been done, or is it required? Therefore, I said there was a case of an approval which was required. That approval has not come, and therefore the specific contention there was the selection, everything has been completed, they are just to approve. And this principle be incorporated.
Yes, madam.
Rashna
Rashna Hills. I'll go.
We'll have this matter tagged along with that.
Yes, madam.
When is that matter?
I think on 23rd. I'll just check it out, madam. 22nd or 23rd.
Yeah, it will be on Tuesday or Thursday.
Yes, madam. Yes. You form a board. I'll just check it out and I'll give the date, madam.
Heard Mr. Enhock?
M. Hussain, madam.
The learned counsel for the petitioner, Mr. N.J. Khatuni, appears on behalf of the respondent numbers 1, 2, and 3. At the matter, instant writ petition is collected with a series of writ petitions pending before this court, pending adjudication before this court, and is fixed on this body. That the instant writ petition be listed along with the.
Yes, I'll give the number also. Obliged, Lordship.
Most of it.
31.
Your lordship. My lord, your lordship.
Have they filed affidavit?
Yes, my lord. The respondent over the drawing in dispersal officer filed, my lord. The commandant, 15th Assam Battalion.
What is this case about?
My lord, regarding family pension, the second Mohammedan wife and her minor daughter, my lord. For your lordship for their share, my lord.
Who are you?
My lord, the other party has also filed affidavit, my lord. The first wife, her minor son, and
You are the second wife or the first wife?
I am the second wife, my lord.
Fantastic. You are the second wife.
Yes, my lord. Yeah, my lord.
Then number 2 is the minor daughter.
Minor daughter, my lord.
Your daughter.
Yes.
Then
my lord,
who is receiving the salary? Getting the
Yes, my lord. My husband died in the month of October 2018, my lord. The marriage took place in 15, my lord. Because of some physical inability of the first wife. First wife herself agreed to marriage and all this. She was the part and parcel of the second marriage. Some conditions the marriage was placed, my lord. Thereafter, my lord, after unfortunately by an accident, the husband died on in the month of October 2018, my lord. After the accident, what happened, my lord? the entire, my lord, matrimonial family, give a very good care till 1.5 years, my lord. And they took my signatures on many papers saying that they are processing the pension. After some days, they left me. Totally, my child and me left. They are not taking any care of that. They have scolded, they have tortured. I left. Ultimately, I left for my paternal house. After leaving there, my lord, now there I have come to know that they have got issued next of kin certificate from deputy commissioner in the name of first wife, our minor son and brother-in-law. Thereafter, I went to my lord from some compromise and all these things. Meeting took place. They have not paid anything. Then I went to the commandant, my lord, with the dispersal of officer. And he said, no, I do not know it. Then I issued the notice to him. After issuing 2 days notice, he stopped the payment. But till then, around 20 lakhs they have already drawn. Since 2018. But then, my lord, again, mutual meeting took place. They have not paid. Now, what happened? They are trying to not to give it to me. Now, the affidavit is filed, my lord, very strangely. The first wife is saying, I do not know a single penny. Entire amount is taken by my father, my lord, father-in-law. And the minor son has nothing to say, my lord. She is appearing on behalf of him also. And the brother-in-law's name is entered in the next of kin certificate in place of me, my lord, by misusing all these things, my lord. Now, my lord, the son also filed, brother-in-law also filed an affidavit. He is saying, I do not know anything. Entire is being done by father. I have no involvement in it. And the first wife is also saying that I have gotten a single rupee. Entire things are done by my father-in-law. I have not got even the ATM card. I do not know going of the money. Anything I do not. Only some signatures are put on.
So you want the money to go to the first wife?
Yes, it is going to the first wife in the name of first wife, but being taken by others.
So that how can this court rule look into that?
My lord, to direct the authority, my lord.
I'll civil suit.
My lord, to direct the authority, my lord.
I'll civil suit.
My lord,
no case. Go by the division. No, Mr. Counsel, tell me, what do I do with the full bench judgment?
My lord, they are not denying that I am not the second wife.
There's no quarrel. You are not entitled to. If you are entitled, you cannot get it in view of the full bench judgment. Only thing is, if you have a claim out there, go to the appropriate forum. I can't help you. Paragraph 23.
And a minor child also, my lord. Minor.
I know, but that point is, I am only one. You have another 3. There were 3 judges who passes that order.
My lord, regarding the child, my lord, perhaps there is no bar for at least this case, my lord. This child of my lord. They're nobody denying. They filed
child or minor, whoever it is, the right is to the widow. First widow. Can't help you. You have seen paragraph 23 of the judgment.
Full bench judgment.
Can't help you. You, I think, take up the issue. Was your husband working as a
police constable?
No, died in harness.
My lord, yes, died in harness.
So is he getting the compassion family pension?
Yes, my lord, the new scheme, under new scheme, new pension scheme. New pension.
He's getting it?
Yes, my lord.
Under the compassion family pension?
Yes, my lord.
Then why haven't you approached them under 5.10? Approach them. There's a clause out there, 5.10 of that particular scheme.
Hello.
Have you looked into it? Why are you doing a matter without knowing what is to be done? Take out 4.5.10. Is that scheme with you, Mr. Bora?
Yes.
Give it to him. You see, 5.10 says this is an exception from the normal family pension. It says that those people who are otherwise also entitled to or comes within the family, they can approach the authority and tell him that, look here, they are not maintaining me. Then the authority can apportion it. That power is being given to them. You have not approached.
My lord, I have approached. My lord,
have you asked for apportionment?
Not pointed, but I have details given.
No, you do that.
My lord, I have.
Otherwise, this court has no business to look into.
My lord, I have filed petition to all, my lord. Kindly see them.
Representation to all is different. thing.
Except
I'm not
mentioning
on
the,
that.
this.
I'm not on that.
clause,
Why
my lord.
apportionment?
My lord, except mentioning the clause, I have filed my lord.
You are supposed to do that. You do it. Why should this court take into account anything? That is not your point out there. You
My lord.
don't know anything, head or tail about that thing.
My lord, my lord, the respondent also took no action, my lord. I have filed, even, of course, not mentioning the exact clause, of course.
No, you don't know. Then you therefore you see, as in the manner you have filed, it is covered by the full bench judgment. I am giving you a way out.
My lord, kindly, yeah, okay, my lord, kindly maybe directed to the respondent concerned. I'll file, my lord. Maybe directed to consider my representation. I'll file.
Who is appearing for the respondents?
Your lordship,
Private respondents. Yes, what is your stand? Are you getting the
I'm
money?
on the behalf of respondent number 13.
Are you getting the money? Mr. Counsel, this court doesn't have so much of time. There are other lawyers waiting. I am asking you a simple question. Are you getting the money?
Yes, ma'am.
You have problem in sharing with him?
No.
Yeah. Who is your senior? Or you are the most person?
HR Chaudhary. HR Chaudhary.
HR?
Chaudhary. Chaudhary.
Chaudhary. HRA Chaudhary.
Not A.
Who?
HR Chaudhary. Hipchur Rahman.
My lord, in the affidavit, my lord,
Yeah,
13,
I
he is appearing for 13 saying, my lord. In 13, he is saying that
Who is 13?
13 is the brother-in-law of the
No,
first
I am not with the brother. No. Where is the
wife has
widow?
filed there, my lord. Wife
Who is
has-
appearing for the widow?
Yes, my lord. Wife has said that the deponent was totally.
Mr. Counsel, who is appearing for the widow? He has no business.
My lord, same person. Same
Are
person.
you appearing for the widow also?
Yes, 11, 12 also. 11, 12 and 13.
More 13.
Then, Mr. Counsel, you try your luck in that.
Brother-in-law.
The name?
My lord, Eke Talukdar.
A.K. Talukdar appears on behalf of the petitioner. A.K. Talukdar appears on behalf of the petitioner. During the course of the hearing, this court had put a specific query upon the learned counsel for the petitioner as to whether he had taken into consideration the clause 5.10 of the office memorandum dated 14/9. Mr. Bora, is it 14/9? 14/9.
That one, new one.
Office memorandum
Yes,
14/9.
Yes, yes.
14/9/2017.
14/9.
The learned counsel, however, submits that he has to look into the same. Is the matter of the
My lord, I suppose to directing the respondent, my lord. If it is filed, my lord.
I would have done so. That person is not there. He doesn't know head or tail anything.
My lord,
What? How can I help you? Tell me.
on the basis of affidavit, my lord, they are not getting money now, my lord. After I know it well.
So they are also in urgency. 32.
My lord, date may be kindly fixed, my lord.
He leaves the matter on 5th of June.
Mobilizing.
Mr. Counsel, you do one thing. I will put it on 18th of June.
10th of June.
No, 26th of June, I am fixing it.
My lord.
I am fixing it on 26th of June. Okay.
Lord,
Listen. So list the matter on 26th of June. In the meantime, the petitioner can very well approach the concerned authority in terms with clause 5.10 of the office memorandum, seeking apportionment of the compassionate family pension on the ground that the petitioner, being a family, on the ground that the petitioner is entitled for a part of the family pension. Do that.
Yes.
That is why I'm fixing.
Yes.
In the meantime, if you do that, if they do it, then yeah.
Obliged.
The pendency of the instant with petition shall not be a bar upon the said respondent to take due action in terms with clause 5.10 of Office Memorandum dated 14/9/2000.
Particularly respondent number 6, man. Particularly respondent number 6, man. Evident.
You do whatever may be,
Obliged.
you do that. Once you do that, that is why I'm fixing it out. Now the matter is pending, he knows. I mentioned about that clause, he will take what.
Highlight.
Yes, madam.
32.
If the lordship matter pertains to my lord, non-payment of leave salary, PF and gratuity and other retirement benefits. Till date, my lord, I respond number
Who is
3.
appearing from Karimganj Municipal Board?
Nobody is happy.
Huh?
Exactly. We have filed our dossier service as well as the affidavit in the last order, my lord. Order date is 7/8/20.
We have not got what? Who is appearing for respond number 3? But this Karimganj Municipal Board is respond number 3 or 4?
3, my lord.
There was
Chair-
somebody
chairman is the
here,
3.
No.
The service was also completed. my
Now, what are you claiming?
lord, the leave salary and all this, PF, my lord. All total, my lord, now 18,15,000 is standing, my lord. And the last month, after repeated presentations and communications, my lord, in the last month, they have paid 1.5 lakhs. Last month, but in month of April, the petitioner received. And now remains 13,45,230. And if against every representation, they used to pay me 1,50,000, sometimes 75,000, this kind of.
See, the
been
problem
5
arises
years, my
because of the director principal administration. Where are they? Who is appearing? Director municipal administration, who is appearing? Why you are not giving money to
Your
the
lordship, we only give them granting aid to the municipal
Why
boards.
you give them?
We have,
How will they survive? Karimganj Municipal Board, they don't have money. Will they pay?
so your lordship, let the chairman, Karimganj Municipal Board appear. Because the dispute is with the Karimganj Municipal Board.
He has been served, he is not appearing, what to do?
Yes, sir. The
That
justice
is
service.
the personal appearance may be directed. Because he's the main person. We just provide granting aid to all the municipal boards. How they utilize the money, it is up to them. Yeah.
Who has received this document? And who is the council? What I put the numbers
1 and 2, hence 5.
1 and 2 and 5.
Right.
Number
Yes, yes, okay, yes. It appears to the record that this court, by an order dated 6/1/2020, directed the petitioner to take steps by way of the stay. The petitioner accordingly took steps by way of the stay upon the chairman of the Karimganj Municipal Board. And file an affidavit of service on 18/1/2002. This court taking note of the order date, taking note of the said service by an order dated 24/2020. Further granted 3 weeks. Number 3, take steps for entering appearance terms with the service made by the petitioner. It was further clarified to mention that if there is no representation on behalf of the respondent, number 3, consequential orders may be passed by this court on the next returnable date. Thereupon, the matter again was listed on 17/3/2020. On the same date, the account that the service upon the respondent has been duly completed. Court further matter on 8/5/2020. However, in spite of receipt of the notice, none have appeared on behalf of the respondent number 3. A perusal of the recognition shows that the petitioner is claiming an amount of rupees 14,95,230 along with interest. The same amount has been sought for the respondent number 3. This court fixes the matter again 14th of June 2023. It is made clear that if the respondent number 3 is not represented on the next date, this court shall proceed with the adjudication of the instant dispute by taking into account that the respondent number 3 has nothing to traverse to the statements and allegations made in the petition. A copy of the petitioner is further directed to serve a copy of the instant order upon the respondent number 3.
Thank you, Opus.
34.
May I please, Your Lordship? This petition is for getting the remaining pensionary benefit, which include revised arrear pay amounting to 245,182, TA bills amounting to 1,04,890, and also for getting interest under the provision of 197A Assam Pension Service Pension Rules 1960. Notice was issued on 23/9/22.
We are awaiting instruction, Your Lordship, in this matter. And secondly, thing is that, Your Lordship, As far as delayed is concerned, Lordship, under Rule 197 A, Lordship, the Secretary is a competent authority to decide the delay has occurred which part, whether it's a petitioner or is a department. Because already before he
Delay
has
for
filed
what?
delayed payment of interest, Your Lordship. Delayed payment of pension gratuity.
197A.
197A of the pension.
On that,
You
Your
are
Lordship,
asking for delayed payment.
yes,
Have you got your pension or not?
I have got, but there was a
This is
delay
a
of
repetition for what?
He's claiming interest, Lordship.
Interest.
I'm claiming
Section
interest.
197.
197A.
To make payment of the remaining retirement benefits which the petitioner is entitled. You
Yes.
have got that?
No, not yet.
Then why
Which
you are not on
includes
striking on that?
arrear pay of 2,45,182.
To make payment of the interest on the delayed payment, that we'll look into it later on. First of all, what about this arrear payment? Why you have not got it?
For that, I have to take the instruction for why the area has not been paid, but he has already filed a requisition before. Where he was claiming his pension, where the delay was, as per instruction, delay was occurred by the, was done by the petitioner.
For what?
Because he had two wives, Your Lordship.
My lord, that is a joke because
he-
I am not appearing, asking for.
Stop, counsel.
And that's
Let
the,
him say.
there is no whisper of this order or of this order, Your Lordship, which he has filed in this report. May I please, Your Lordship?
Oppression. You have filed earlier with petition.
Yes, from that I.
Have you
the
mentioned
court-
it about this thing in your petition?
No, he has mentioned about 2018 with petition, not 2021 with petition.
Oh, how many petitions you are filing? What is wrong? Name is same, Mofizuddin Ahmed Hazarika. Where you are from Sipsagar?
Yes, ma'am.
Yes, I like to file many repeat. Yes, there was a direction on 15/9/2021. What have you done?
That instruction I have to take a Lordship. 15, that instruction I have to take a Lordship. We are awaiting instruction on that. What steps have been taken, Your Lordship?
Why?
Because here is
Didn't the
asking,
court clear it that he has 2 wives, 4 wives is not the matter. You are to pay it.
yes, Your Lordship.
Then why haven't you paid it?
But at this situation, he's asking for the interest in the delayed.
Forget
payment,
about the
Your Lordship.
interest. We'll look into that. That I will pass an order again
Yes, sir.
for interest, how much it is to be paid and from whom it is to be taken. Don't worry that. First, when are you going to pay this amount? How much amount? 2 lakhs?
2,45,182
Okay. When are you paying that?
and TA bills also. TA bills amounting to
Lordship, I'll take the instruction on that. In what
1
is-
lakh
in what limit time you can
4,890.
pay this.
As far as Lordship prayer is concerned, only specified on 2 aspects. only, Lord.
Prayer is only on retirement benefits, no TACA business. We are only concerned with
Yes.
retirement. Don't come up. You like to anyways file writ petition after writ petition. After you file another one. Heard, Mr.
MR Sodial.
And so the learned counsel appearing on behalf of the, your name?
RR Gogoi.
RR Gogoi
Yes, sir, Lordship.
appears on behalf of the Forest Department. You are appearing? Mr. B. Chakraborty appears for the Accountant
number
General AE. The learned counsel for the petitioner submits that the petitioner has got certain retirement benefits, but however, an amount of rupees
2,45,182.
is still pending due from the respondent Forest Department. This court, in the earlier round of litigation, that is in WPC number 348/2021, dated 15/9/2021, had directed the respondent forest department to do the needful so that the finalization of pension of the petitioner's pension is done at the earliest. 2 years have gone by, but the petitioner still awaits to receive the remaining part of the amount mentioned herein above. This has led to the filing of the second writ petition, claiming the said amount along with interest at the rate under Rule 197A of the Assam Service Pension Rules 1969. The question of pension would be, the question of interest in terms with Rule 197A would be taken at a later stage by the court. However, the Forest Department, the legal counsel of the petition for the Forest Department shall apprise this court on
After 2 weeks a lot. After 2 weeks or 1 week a lot. Needed.
today is what day? On 24th of May 2023, on which date the said amount of rupees 2 lakh so and so shall be disbursed to the petitioner. Liberty is given to the petitioner to mention the matter for upgrading.
All right.
35.
May please.
Yes,
My
Mr.
lord,
Dey.
matter relates to non-payment of retirement benefits, my lord.
All matters are same. Madam 6 instruction is.
That's it, proper instructions not received, but we have some instruction received, but
Is he entitled to?
that's it not. It's in instructions, here said,
Let me read it.
department is proceeding the matter to come to a decision about the regularity in holding the post of stenographer grade 1 by the incumbent which is still awaited.
My lord, petitioner retired from-
Retirement benefits and gratuity leave encashment group insurance to the petitioner to the retired on 31/12. Yes, why you have not got this amount, Mr. Day?
My lord, it is best known to the respondent. I am not, but because I am retired on my lord 31/12/2022. Since then, I am pursuing for my retirement benefits, but it was not paid, my lord.
When were you appointed?
My lord, petitioner was appointed in 1984, 15/6/1984.
Regular?
Regularized on my lord in the post that is in 2015, my lord, 5/5/2015, she was absorbed.
Two?
Absorbed regular post, my lord, that is annexure, my lord.
You were in DRDA.
DRDA, my lord.
DRDA is nothing to do with the government.
My lord, absorption order is there, my lord, page P7, P5, page 17.
How are you going to get the pension?
Against the regular sanction post, my lord. Absorb.
Understood. You come under the new pension scheme? You come under the new pension scheme?
My lord. My lord.
So you will be entitled to the DCRG.
My lord.
Gratuity he is entitled to.
Yes.
In view of the personnel department circular dated 1/2/2021. And what else? You are not entitled to any other pension?
I am not receiving pension, my lord, but I am filed this rate petition for gratuity, leave encashment, group
Gratuity he is
insurance.
entitled to in view of that office memorandum. Leave encashment is also you are entitled to.
My lord.
Group insurance money is entitled to.
Yes, my
Why you are not paying that?
That's it, some
Is a DRDA born employee who was absorbed in the sanction post of so and so in Iman. It has so and so has already issued demand while disposing of the Guwahati. Yeah. Before I looked into it, it is given with effect from their absorption against vacant sanction post. For counting the service of the DSA born employees for the payment is processing the matter for obtaining approval from the Honorable Cabinet as described by AI, which is presently under process. However, the department has it for payment of leave encashment to the DRDA bond employees as per cabinet. I have received the proposal for so and so. Wherein it is mentioned there is no post of stenographer grade 1 of DRDA or incumbent is underqualified. As the gazetted status also to you were absorbed in 2017.
Yes, yes, my lord. 1/8/2017.
Question. So the fact that he has been absorbed, there is no question. The fact that he is entitled to live in encashment is also not in question. The fact that he is entitled to the gratuity is also not in question. When
So we need, we'll take instruction.
instruction is already there,
Yes,
what further better instruction is there?
update instruction.
You are with the PNRD department. Oh. See, there is always a tussle between PNRD and finance. That is the biggest problem you are facing. But Mr. PC Day, the learned counsel appearing on behalf of the petitioner. Enbora
And
appears on behalf of PNRD department. The finance is there. Will not meet finance.
Accountant general there.
And so appears on behalf of the accountant. AAC. Who appears?
Mr. Dhar, my lord, in the last occasion, my lord. The last order.
Ms. Enbora, the learned counsel submits that he has received some instructions from the Secretary Panchayat and Rural Development Department. However, the said instructions are dated 1/12/2022, and as such submits that she would like to take fresh instructions as regards the present status pertaining to the matter seeking approval from the cabinet for counting of past service of DRDA employees for payment of DCRG, as well as also as regards the payment of leave encashment. Accordingly, listed again on 10th of June 2023, on which date the learned counsel shall obtain the necessary instruction. You keep this.
Next date.
10th of June.
$38.
Good, Mr. Honest. Yes.
Lordship. So the petitioners before Lordship are Malad retired employees of Malad Assam Hill Coal Industries Development Corporation. Since 2004,
That pertains to what?
but their petition of Malad their salaries. They are retired employees, Malad. Their salaries were not paid since 2004.
but simply, my lord, at the intervention of this honorable court, have paid the salaries, the petition, but at the rate of my lord, 50 commission recommendation, whereas the petitioners are entitled, my lord, their salaries comes from recommendation of pay and 7 pay. Directed to the response.
VRS. You've gone on VRS, no?
No, only. They're all retired employees. Currently.
Retired from where? Assam Hills Area Development Corporation.
My lord.
You
When
retired
yes.
when?
My lord, the petitioner number 1, my lord, he retired on 15/2/2016. And yes, dates, my lord, I have mentioned it. My lord.
Affidavits have been filed.
They have not filed affidavit.
They are filing affidavit.
Lordship, I'm for the respondent number 5 MD.
Yes.
Problem is that recently only salaries area salaries were paid to them on 5th pay commission as per 5th pay commissions. So to ask for 7 pay commissions, self-financing corporations, it may not be possible right now because it is just surviving now. Therefore, claim for 7 pay commission at this stage may not be. I would like to file the details affidavit.
Please.
Because we got the state has given us money, some 6 points, almost 7 crore to us, 4 crores that we have already paid them in area salary because that corporation was defunct since 1992. Only 2009 onward it has been able to survive somehow. Therefore, at this stage, if we finance them, if we pay them 7 pay scale, in that case, the corporation will not survive. Yeah, I get a little golden X.
Understood. There's no problem. You want to file an affidavit, file your affidavit.
I'll file this.
Mr. B.K. Bhagavati, the learned counsel appearing on behalf of the respondent number 5 who seeks an accommodation of 4 weeks for filing affidavit.
I mean, because there are some 4 weeks time.
3 weeks. How much?
3 weeks.
I was giving you 4 weeks. You
4
want
weeks, 4 weeks, lots.
4 weeks time for filing affidavit. 17th of July. It does. Okay.
$44.
Not received or instruction, my lord, so time may be allowed for filing affidavit.
Where is Mr. Gogoi? Where is he?
He is left.
Where is he? They are in the court.
Yes, sir.
Ask him to be here. Get up sometime.
$45.
Yes.
Or family pension and the retirement benefit. So my lord, earlier I have filed a writ petition, my lord, that is page, my lord, order page 19, my lord. So, Rational number 3 was.
Who died?
Rational 3 was directed. So Rational 3 completed his work, my lord, and that was submitted, my lord, at page 27, my lord. And all pension papers submitted.
Earlier,
before the-
repetition was filed. Yes, Mr. Chaudhary.
Lordship, here, while processing the file for payment of family pension, a legal notice has been served by the petitioner's mother and brother stating that the marriage of the mother of the lordship deceased employee, stating that the petitioner's marriage with the with the deceased is invalid, and they have filed a title suit at Moholdoy Court, lordship. And there
Have they got an injunction there?
they have not produced to us, lordship.
We are not concerned with such
Then,
things.
lordship, under the pension rule, she is since there is a registration of marriage certificate.
Yeah, registration of marriage certificate, then you have to pay.
Yes, lordship, that has been now processed. Lordship may take it up after 3 weeks, lordship. In the meantime, I will submit the status.
Or Mr.
M. Hussain. M. Hussain.
M. Hussain, the learned counsel appearing on behalf of the petition. Mr. B. Chaudhary appears on behalf of the respondent numbers 1, 2, 3, and 4. This is the second round of litigation on account of non-grant of the family pension. The learned counsel appearing on behalf of the Finance and Taxation Department submits that the file pertaining to the family pension of the petitioner is presently under process. Taking down the same. The matter will be listed again on 12th of June, on which date the learned counsel appearing on behalf of the respondent shall apprise this court as regards the status of the family pension proposal of the petition. He died in harness.
Yes, lordship.
Yes, no.
If he died in harness, wouldn't they be entitled to compassion family?
Lordship, at this moment only
Yes,
the
You have
pension
applied
paper-
that.
Forty-nine.
Obliged.
So the government has given or requested,
Yes, madam. They've submitted the proposal to the government, madam.
or Mr. A. Dekar, the learned counsel appearing on behalf of the N.J. Katunia appears on behalf of the
Elementary
appears on behalf of the Elementary Education Department as well as also the Department of School Education. During the course of the hearing, the learned counsel for the standing counsel has produced a communication dated 16/5/2023 issued by the Director of Elementary Education seeking the approval, seeking the sanction of an amount of rupees 2,42,358 from the Secretary to the Government of Assam, Department of School Education, so that the said amount could be paid to the petitioner. Taking into account that it was only on 16th of May 2023, the said proposal was submitted to the Secretary to the Government of School Education. Sorry, not 7th of June, 7th,
Madam, can it be later?
14th of June 2023, on which date the learned counsel appearing on behalf of the Department of School Education shall apprise this court as regards the status of the proposal seeking sanction. The communication dated 16/5/2023 so placed on record is kept, so placed and is marked with the letter Y.
Obliged, lordship. Obliged, madam.
53,
Lordship, I have received the telephonic instructions today itself. The enquiry officer has already been appointed. And he also told me that he will try to complete the enquiry within a period of 1 month. The last part of your Lordship's last order.
Here, in similar nature of case, Lordship already passed the order in regarding Devabrata Gogoi on 3rd of May. Lordship, sir. And my lord, regarding the suspension, my lord, since the last time I've been told that para 21 and 22, and I have gone through the Vijay Kumar Chaudhary case. In that case, I have found that in that case, my lord, prior to 3 months, my lord, the extension was done. Review was done. But in our cases, no such act. That is why this 22 Lordship pointed out on that particular day. I've gone through the case, my lord. That
No. Mr. Chetri.
Yes.
There, what has happened is in that judgment, there were 6-7 times the review was done,
Yes.
Ajay Chaudhary.
In that case, my lord.
But there was no memorandum of charge given.
Yes.
If you see paragraph 2 also of the judgment, no memorandum of charge given.
And since
But while the matter was pending before the Supreme Court, so therefore he initially moved the CAT. CAT said, you have to give this within such and such time, otherwise the suspension will be reinstated. Then the matter, the union challenged it out there in Delhi High Court. Delhi High Court said that no, you have no power. The CAT had no power to do so. So the matter went to the Supreme Court. While the matter was going on in the Supreme Court, at that point of time, the memorandum of charge was given. That is why paragraph 22 comes.
Paragraph 22, my lord, only I have found, my lord, para 22.
See the language of paragraph 22. Now,
Yes.
as the petitioner has been given the memorandum of charge, the above declaration of law shall not be effective.
No, only my part is this. My commission before this honorable court is.
They are finishing it up when 1 month.
I'm not against the departmental proceeding. Whatever it is continuing, my lord. Only on suspension, my lord, that part since in Deepak Mali case, it has also been said that beyond 90 days cannot run a single day. Is said, my lord, in Deepak Mali. And if they have to issue the suspension order, then it has to issue space. Otherwise, not.
But Mr. Chetri, Mr. Chetri, Deepak Mali is a case pertaining to under the CCS rules. There's a provision of 10(7) where it is categorically mentioned that it has to be reviewed. Where is the provision under Rule 6?
And since Lordship has decided all this same matter, my lord.
Which one?
Devabrata Gogoi. Lordship's decision. Only considering all this Ajay Chaudhary case and my lord.
I did so. In respect to that, I don't know. But Devabrata Gogoi is a different matter.
No, here also, my lord, no such charge sheet or this.
Charge sheet you are here, inquiry is going on.
Lordship,
Devabrata Gogoi cannot be that matter.
It is Lordship's order.
Devabrata Gogoi is that matter where you are appearing, you appeared, I suppose.
I'm not.
No, that I have disposed of.
Kulendra Das. I was appearing.
Yeah. Yeah, the charge sheet is not being given.
No, within 3 months, it does it. not.
No. You see, taking into account the above and as on date, there is no memorandum of charge sheet, paragraph 7. That is how.
In my case also, my lord, it is beyond 3 months a charge sheet was given.
See, when I decided this point, at that point of time, there was no charge sheet given.
No,
There's a difference to the
yes,
effect.
yes.
Therefore, I remember categorically all matters which I've done it. This forest, where the forest, Mr. Gogoi was appearing, D. Gogoi. He categorically submitted that, look here, neither any departmental proceedings, nor charge sheet, nothing has been given. That is the
Here,
reason why this was.
My lord, similarly, my lord, my case also, when lordship of the matter, my lord, and the lordship has categorically stated in the order itself that even after the expiring of the mandatory period of 3 months, no such charge sheet or charge memo was furnished to the petitioner. And when lordship severally asked them to get the instruction, then a subsequent stage, they have come with a permission that after about 4 or 5 months, they have issued the charge sheet. And since lordship is very aware, and yes, lordship has categorically stated that, and there is also a government amount that once they have not issued the charge sheet or charge memo 3 months, meaning thereby the case, the suspension.
Mr. Chetri, unfortunately, I have to tell you one thing. You see the judgment of Justice B. Chauhan, Dr. B. Chauhan, in 2013-16 SEC, categorically mandates that the question of interference in these types does not warrant. Yes, this was a power which was being exercised out there on the basis of Ajay Chaudhary. Now, Ajay Chaudhary is very clear. Ajay Chaudhary says about 167(2). Now, if you see, let us see the judgment of the Supreme Court in the case of Rakesh Paul, 167(2). There, in the last paragraph, it has been mentioned that if this person is released also, he can be again arrested. See that? And then he will be entitled for regular bail. That is why the same thing has been given out here. Now, in the case out here, let us assume, under 167(2), a charge sheet ought to have been filed on the within 60, 90, 180 days, whatever may be. If it is not filed on the 68th, that means on the 61st day, a person gets a right. But on the 67th day, the charge sheet is filed, but he does not file the application for default bail. Would he get the benefit? No. The same is the principle here.
Here, my lord, apart from this, all this, my lord, there was only the audio clip. The allegation, main allegation here, only the audio clip. And audio clip doesn't carry any such evidence or all these things, my lord. Apart from that, only on the basis of this audio clip, he has been made suspension. Now, only thing is this, my lord.
But Mr. Chetri, how can this court go into that in a proceedings under 226?
And
that there is no evidence.
There was no any such criminal cases, my lord.
Understood, but is it within the permissible jurisdiction of this court to do it under 226?
Only, my lord, I'm not praying for lordships regarding the quashing of the proceeding, all these things. I'm not praying, and it is not my fair commission on my part to say that let it be continued. But the thing is this, my lord, since regarding suspension, so my prayer will be the person is this petitioner is entitled for reinstatement. I'm only this limited.
Mr. Chetri, the problem is this. Allowing this petition would lead to floodgates in other petitions. There is a particular thing you have to stop. Here I have stopped out there as regards this. A review has to be done. But a review, if you see, there are various office memorandums out there. Ajay Chaudhary does not say particular period within which a review has to be done. The review has to be done in terms with the office memorandum dated 4/2/2020. It says that it has to be done within 6 months. That is the power which has been given.
6 months cannot be at a time. Whatever it is, my lord, only.
And
I have the
only, you
limited-
see, the Deepak Malik case, only one thing may come into that if a suspension order has been passed and given a particular date, if it is not renewed within the lifetime of that, you cannot extend it. That is the principle which can at best be applied. Otherwise, Deepak Malik is a case on the 10/7, wherein it is required that you have to do that. Problem arises with the judgment of the Supreme Court, which I was referring to, 2013-16 SSC. Very difficult. I'll give it to you.
13-16 SSC 147.
Two 2013-16 SCC 147.
I will look in. I will look.
And you see this judgment, this paragraph, I'll just. Para 26, scope of judicial review. If I may read it. The scope of interference by the court with an order of suspension has been examined by the court in large number of decisions, particularly in so-and-so, wherein it has been observed that even if a criminal trial or inquiry takes a long time, it is ordinarily not open to the court to interfere in case of suspension, as it is the exclusive domain of the competent authority who can always review its order of suspension, being an inherent power conferred upon them under Article 21 of the General Clauses Act 1897. And while exercising such a power, the authority can consider the case of an employee for revoking the suspension order if satisfied that the criminal case pending would be concluded after unusual delay for no fault of the employee concerned. Where the case charges are baseless, malafide, or vindictive, and are based only to keep the delinquent employee out of her job, a case for judicial review is made out. But in a case where no conclusion can be arrived at without examining the entire record in question, and in order that the disciplinary proceedings may continue unhindered, the court may not interfere. In case the court comes to the conclusion that the authority is not proceeding expeditiously as it ought to have been, it results in prolongation of sufferings for the delinquent employee. The court may issue directions. The court may, in case the authority fails to furnish proper explanation for delay in conclusion of the inquiry, direct to complete the inquiry within the stipulated time. However, mere delay in conclusion of the inquiry or trial cannot be a ground for quashing the suspension order if the charges are grave in nature. But whether the employee should or should not continue in his office during the period of inquiry is a matter to be assessed by the disciplinary authority concerned, and ordinarily the court should not interfere with the order of suspension unless they are passed in malafide and without there being even a prima facie case evidence on record connecting the employee with the misconduct in question.
Here, there is no grievous charges. And that apart, my lord, whatever charge have been made out, my lord, totally, my lord, on imagination, my lord. Nothing, on imagination, somebody has made the telephone call and that video record has been that audio.
Now, one matter I have touched it. where I have set aside the inquiry and not the inquiry, the suspension order. That was the matter pertaining to, yes, I remember, some Munmun Bogotoki or something, I forgot, something like that. There was a case of OBC certificate. You were there, na? No. There was an OBC certificate which was issued. It was found out that she couldn't have got that OBC certificate, but she was enjoying. And on the basis of that, her OBC certificate was cancelled on the basis of some order by an inquiry, and that was cancelled. That was challenged in a writ petition. In the meantime, that writ petition, she was also suspended. The suspension order came before me. The other writ petition came up before Justice Jamil. Justice Jamil passed an order setting aside that order by which the DC has cancelled and the DC was directed to again renew it. Now, the DC had renewed it and the state did not file an appeal against it. And when the state did not, the matter ended out there. You had appeared? Yes, you appeared. You said that there was an appeal which had been filed. I remember you were there. You said that the tribals, the OBC or some association had filed an appeal before the division bench. Remember?
Yes.
You appeared. I remember.
Yes. Now I remember.
Yes. I set aside that the entire suspension order because there was no materials on record. Because the material was that there was no OBC certificate. Remember? That is a different.
That's here also.
But here there is some material.
No, here also, my lord. There is no material at all, my lord. No material, my lord. Only on the basis
No, how can this court look into it? But there, on the basis of an order being passed by the High Court, that document, and there was again a fresh issuance of the OBC certificate.
Lordship,
there was no challenge. The government had accepted the document.
That audio I have, my lord. If Lordship wants to hear this audio, Lordship will very much will be clear to know that what type of this allegation have been made. As because somebody has alleged that this mandal has will take this much of amount and this mandal will take much of amount. I have heard so all this only this conversation made by someone else. Then this audio has been placed and accordingly he has been made. How can it be? Tomorrow somebody will allege me. Does it mean that I will be guilty of that? Well, had there been any written statement?
No, Mr. Chetri, the best this court can do is direct them to complete the area within a particular period. Nothing more than that. Very difficult. And that too recently, the judgment of the division bench says that even under Ajay Chaudhary, if a person gets the benefit, then also the power is still there under 6(1) if the proceedings are initiated to again suspend him. What to do with that? State of Assam by Ajit Sonwal.
Yes, sir. Lordship has reflected.
Eh?
That decision has been reflected in Lordship.
Mr. Datta keeps that judgment with him in his hands. Yeah, I don't require it. I remember it. See the last paragraph of the judgment. Have you got it? The division bench judgment.
Ajit Kumar Sunal.
The last paragraph.
Stated herein above. Para 18. We hold that there is no merit in this appeal. However, since Rule 6(1)A of the Rules of permits the authority as an employee under suspension when a discipline proceeding against him is contemplated or is pending, and considering the fact that this proceeding has in the meantime been initiated against respondent 1 by serving a term of office, we make it clear that this order could not come in the way of disciplinary authority from exercising jurisdiction under Rule 1 of the Rules of and issue a fresh order of some regarding fresh order. So in my case, my lord, what I understood, my lord, from your lordship's order, my lord, that once this within the period of 3 months, it has not been. Lordship also has clearly stated about Ajay Chaudhary's para 21, my lord. and this Ajit Chunal and Regabuddin
Because
Ahmed
today,
case.
Mr. Chetri, I have already disposed of 3 transfer matters, the suspension matters, and thereby reinstating everybody on the ground that there has been no memo of charge submitted till date by the respondents, as they say. So that is why I have reinstated. But once it is being done, when he says out there that within 1 month I am going to complete it, how can I do it?
That part, my lord, yes, stated, my lord. How long it will take, my lord? Do not know. But
No, if it takes, therefore I'm telling you this judgment. I'll do one thing. You look into the judgment of 2013-16 SCC
I will
147.
look into, my lord, on that.
Then we'll again hear you on next Tuesday.
Yes, that day, Lord.
Have it. Heard Mr. B. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. H. Sharma appears on behalf of the respondent number 2, 3, and 4. Mr. S. Datta appears on behalf of the respondent number 1. Let this matter be again listed on 23rd of May 2020. Okay.
Okay. 58 orders.
The matter Mr. B. Gogoli. Yes, why this matter has come up for orders? Okay, orders are
Retired from service on 1st of March in Melody.
Order under which has appeared before under meeting.
DRDA salary.
Why the matter has come up? This is the matter for admission after 2 weeks.
I ordered it 19/12/2015.
Let it come up for admission.
$59 orders.
May I please, your lordship?
Yes.
Lordship, on 10/2/2023, your lordship has directed to the respondent to release the provisional pension as well as DRDA, lordship. And the last occasion, the respondent has.
When?
Lordship.
When did I die? On the other hand, Mr. K.
10 to
accordingly, matters
2023.
here is not present, there shall be main non-time.
31/3/23.
Oh, yes. What about the provisional pension?
Lordship, it has been complied with.
No, lordship. As per my instruction, lordship, the petitioner has not get anything till that, lordship.
Okay, but you say that it has
Yes,
been
Lordship.
complied with. There has to be some document to the effect.
Yes,
Lordship,
lordship.
there
they
was a
have-
document, Lordship, which was flag marked as X and Y respectively.
In
On the last
compliance
date,
with the
Lordship,
order,
Mr.
it
K. Gogoi-
explains so instruction conveyed in month pending regularization of unauthorized act. Hereby accepted the effect is of this was done on 24/3/2023.
Yes, Lord.
Time. Now, this provisional pension has been, these are orders being passed. Now, these orders have to be communicated to the treasury officer. Don't you think so?
Yes, Lordship, it was communicated, Lordship.
Where? Show me. Oh, yes, copy to the treasury officer. You are there? Who is the treasury officer here? The treasury officer party?
Yes, Lordship.
No,
No, Lordship.
there the problem arises.
999. One. Yes.
Heard Mr. H.K. Das.
N.K. Sharma. N.K. Sharma, lordship.
N.K. Sharma, the legal counsel for the petitioner, Mr. D. Upamanyu appears on behalf of the Higher Education
1
Department.
and 2, Lordship.
Full stop. This court on 31/3/2023 duly recorded that the Higher Education Department had already sanctioned by its separate orders dated 24/3/2023 the provisional pension as well as also the provisional DCRG. The Learned Counsel for the petitioner submits that the said amount has not been paid to the petitioner till date. It appears from the documents enclosed as Annexure X and Y, and documents marked as Annexure Y, X and Y to the instant record, that the orders of provisional pension and the provisional DCRG were also endorsed to the Treasury Officer. Naga. Also, Mr. Arbor Pujari, who is present in the court, is requested to take information from the Treasury Officer Naga as to whether, in pursuance to the orders dated 24/3/2023 issued by the Director of Higher Education, the provisional pension as well as the provisional DCRG have been directed to be disbursed from the office of the Treasury Officer Naga. Mr. D. Upamandu, the Learned Counsel, appearing on behalf of the Higher Education Department, serve a copy of the orders dated 24/3/2000, serve copies of the orders dated 24/3/2023 to Mr. Arbor Pujari for taking necessary instructions. List the matter again on 14th of June 2023. The registry shall show the name of Mr. Arbor Pujari. I'm not making you a party, not necessary, but I'm asking.
And Lordship, the respondent has
Arbor Pujari has SC finance, kindly, my.
As SC Finance.
That much will do.
Lordship, and respondent has yet to file it. File Lordship.
They don't file affidavit. These type of matters, if you then trouble these big lawyers, what will happen?
44.
Obliged, Lordship.
What is left?
Yes, why haven't you filed affidavit?
This one.
No affidavit filed.
Sometime maybe.
Madam, this is a whole matter. Notice was issued on 28/11/2022. This court made it very clear to file the affidavit by 2/5/2023, and the petitioner was, if so advised, may file the reply by 8/5. Why that has not been done?
This is the inspection.
Heard Mr. B. Sinha, the Learned Counsel, appearing on behalf of the petitioner. Ms. A. Bora appears on behalf of the NHM. It appears on record that on 28/11/2022, this court had issued notice. Thereupon, the matter has been listed on 4/1/2023, 10/2/2023, and 17/3/2023. But till now, the respondent, NHM, have not filed any affidavit. Taking into account the same, this court fixes this matter on 28th of June 2023. It is made clear that if the affidavit is not filed by the respondents on 26th of June 2023, this court would have no other option but to impose cost. And accordingly, the mission director, NHM, is put to notice as to why cost of how much? 25,000 should not be imposed in such circumstances.